Both members of defense counsel are now present, Your Honor.
Okay. Could you do me a favor and rename yourself on the screen to indicate that you're with the defense, just so we can keep it straight?
No problem, Your Honor. 1 second.
Okay, and do we have both advocates for the prosecution here as well?
Yes, Your Honor.
Okay. In 1 second, we're going to perform a conflicts check, make sure we're good to go. All right, can I have the 4 advocates turn on their cameras briefly so the scoring judges can see your fine faces and make sure they don't have a conflict? All right, scoring judges, look at your screens and please tell me if you recognize any of the participants to this mock trial round and whether or not you would have any conflict with them. If you do have a conflict, you can send me a private chat. Okay, thank you, advocates. And it looks like we're good to go, so I'm going to let the tournament director know. Thank you for your patience, everyone. Just waiting for the all clear from the tournament director, and then we'll get started, okay? Once again, everyone, thank you for your patience. It looks like although we're good to go here, there's a couple issues with the other courtroom, so we're just waiting to make sure we don't need to shuffle anybody around. Thanks again. By way of update, everyone, it looks like we had issues in 3 or 4 courtrooms, and they are now solved in all but one. So thank you again for your patience. We are getting closer to getting the all clear. Okay, we have 4 attorneys, we have 3 jurors, and we have 4 witnesses, and we have the all clear to go. So once more, can the advocates share their video feed? We're ready to begin and call the case of State of West Carolina versus Timothy Ray. My name is Judge Yelverton. Scoring judges, you're already doing this. I would just ask that you remain with your video and your audio off during the course of the trial, so as not to cause a distraction to the advocates. And you should also have your video set to hide all non-video participants so that you can see the trial proceed correctly. That means the only people on the screen right now should be the advocates and myself. And with that, we are ready for appearances. Will the attorneys please make appearances for the record?
Yes, Your Honor. Adrian Ward for the state.
And Victoria Pasculo for the state.
Your
For the
Honor, my
defense.
name is Megan Ledesma. That's Ledesma, and I, along with my co-counsel,
Cameron Galvan, and that's Galvan, and we represent the defendant, Timothy Ray.
Very good. Do both sides announce ready for trial?
Yes, Your Honor.
Your Honor, there are a few housekeeping matters we would like to take care of prior to beginning.
Okay. Does the prosecution have any housekeeping as well?
We do, Your Honor.
Okay, why don't we take up the prosecution's housekeeping, and then we'll go to the defense housekeeping, and then we can carry on to any substantive motions. So first, Mr. Ward and Ms. Pasculo.
Yes, Your Honor. First, we ask that regardless of how the evidence is introduced at trial, that we keep the pre-marked exhibit numbers.
Yes, that's granted.
Second, Your Honor, in light of this trial being conducted virtually, the local rules aren't clear as to whether the defendant will be represented by a Zoom tile. How would Your Honor prefer the state identify the defendant?
You can just have the witness identifying the defendant do so constructively. He doesn't have to actually appear in a Zoom tile. I'd like to keep this as close to real life as possible, but no one's going to hold you to the fact that there's not actually a Zoom tile present for the defendant.
Yes, Your Honor. Next, Your Honor, would you prefer a formal tender of the expert witnesses or simply lay the foundation and continue?
I think I would prefer a formal tender at the time that you are going to start offering expert testimony from them, simply because it'll help keep the record clean as to when you are going to elicit expert testimony.
Yes, Your Honor. Next, the state requests that all evidentiary arguments be heard constructively outside the presence of the jury.
That's going to be granted. The only thing that I'm going to mention about that is I'm going to ask for you to ask to approach when you want that to take place on the record outside the presence of the jury. Otherwise, if you don't ask to constructively approach, I'm going to assume that we're still in front of the jury. Okay?
Yes, Your Honor. Finally, the state just wanted to put the defense on notice that during summation, we intend to use an exact printout of Exhibit 29, should it be entered into evidence, just for closing arguments. There's no alterations made to the exhibit. Just
Okay. If that exhibit makes it its way into evidence, then you're free to use it for all purposes.
Yes, Your Honor.
Okay. Anything else in terms of housekeeping from the prosecution?
No, Your Honor.
Okay. For the defense, let's take up your housekeeping now.
Yes, Your Honor. As we have not had the privilege of practicing in your court before, we would just like to confirm that we are following the federal rules of evidence for today's proceedings.
That's correct.
Your Honor, we would also ask for permission to move freely around our virtual wells for closing and opening arguments.
That's granted.
Your Honor, we also ask that we may be able to stand during direct examination as well as cross-examination.
Yes, I think that'd be best.
Your Honor, pursuant to Federal Rule 615, we ask that all lay witnesses be constructively sequestered, except for both sides' experts.
Okay, and is there any disagreement from the prosecution that the experts are persons necessary for the presentation of your case?
No, Your Honor.
Okay, then the two fact witnesses will be sequestered constructively, and the experts are excused from that rule.
Your Honor, may we also assume that the jury charge has been read prior to closing arguments?
You may.
And a brief sidetrack for the housekeeping rules for today, Your Honor. My co-counsel and I will be switching rooms during each of our respective witnesses, just to let the court know. And to confirm, Your Honor, demonstratives are allowed to be presented during this trial for today's proceedings, so long as they've been presented to opposing counsel 30 minutes prior to the beginning of trial.
That's my understanding. If there are any objections to the substance of the demonstratives, such like they don't accurately reflect testimony or the like, then I think it's incumbent upon the respective counsel to make those objections at that time. But with that understanding, yes, you may use demonstratives.
Yes, Your Honor, and that concludes the defendant's housekeeping matters.
Okay, then let's take up any substantive motions that the state has to offer prior to proceeding to opening statements.
Yes, Your Honor. Your Honor, by way of background, this is a murder case that involves the death of a child at the hand of his father, the defendant. Now, the defendant has given notice that he will be asserting an insanity defense. The defense's psychiatry expert's report reprints a direct quote from the defendant during the psychiatric evaluation of that defendant. That includes a reference to expressing fear that he, quote, knew he was going to jail for what he did. We want to put the defense on notice that we will be eliciting the statement at trial as an offer of proof that the defendant was malingering or faking symptoms of insanity for his defense. We anticipate both experts to testify that when a defendant is facing jail time, they are much more likely to malinger.
Okay. And did the parties have the opportunity to confer on that prior to trial, or is this the first time this is being brought up?
This is the first time that we are hearing this, Your Honor.
Okay, do you have an objection to them eliciting that testimony?
Yes, Your Honor. First and foremost, we object to that is substantially prejudicial, but furthermore, because opposing counsel has indicated that it will be coming from expert witnesses pursuant to the local rules of this jurisdiction, as well as the federal rules of evidence 704B, Your Honor, neither experts are allowed to testify as to whether the defendant knew what he was doing on the day that Nathan was killed, as well as whether those actions were wrongful, Your Honor. To allow an expert witness specifically to testify regarding these matters violates not only the local rules within our jurisdiction, but as well as the rules, the federal rules of evidence 704B.
Hey, Mr. Ward, would you like to respond to that?
Yes, Your Honor. In regards to the 403 objection, Your Honor, the defense's statement is highly probative of malingering. Now, at no time will the prosecution make reference to the jail time or punishment that the defendant will be facing if convicted. We understand that would be inadmissible. However, in terms of the local rules that opposing counsel has referenced, the case of Pasquarello v. West Carolina, that case is silent as to whether or not the experts may testify to the potential for malingering on behalf of the defendant.
Okay, and Ms. Ledesma, since this is taking on the form of a motion in limine or motion to exclude, I'll let you have a reply to that argument.
Yes, Your Honor. We respond that even though opposing counsel wishes to use it primarily for malingering, the way we anticipate it would come out from the expert specifically goes to an essential element of their case, which violates directly, which is the ultimate issue in today's case, and directly violates 704B. We understand that they would like to opine regarding malingering. However, Your Honor, the nature of the statement and the fact that the testimony would be elicited through an expert directly violates 704B, as well as the local rules.
I tend to agree that the manner in which that testimony or evidence is elicited is going to be important to whether or not it does come out as admissible. And for that reason, I'm not going to rule that it's excluded at this time, but I would grant a motion in limine on it. So as we develop that testimony, Mr. Ward or Ms. Pasculo, please ask to approach before you go into that statement. Okay?
Yes, Your Honor.
Okay. What else do we have from the state in terms of substantive motions?
Your Honor, the state moves to preclude any opinions given by Officer Wentz about the defendant's mental state based on when he spoke to the defendant. As my co-counsel, Mr. Ward, had said, this is a murder case that involves the death of a child at the hands of his father. Officer Wentz was the first officer at the scene, and we anticipate that Officer Wentz will testify as to what he thought the defendant's mental state was at the time, and therefore we move to preclude Officer Wentz's testimony that he thought the defendant was having delusions and in a bout of insanity. Under 701C, a lay witness is precluded from testifying to anything based on scientific, technical, or otherwise specialized knowledge within the scope of 702. And this would require expert testimony, and the defense is able to and will be, from our understanding, bringing an expert to present expert testimony as to what he or she thought the defendant was experiencing at the time.
Okay, from the defense, a response to that?
Yes, Your Honor. Pursuant to 701, a lay witness is allowed to give their lay witness opinion regarding events that they rationally perceived at the time that they perceived it. We will not be eliciting testimony today from Officer Wentz eliciting what he believed the defendant's mental state was, as Officer Wentz is not qualified to give that opinion. However, we will be eliciting information regarding what Officer Wentz perceived based off of his interaction with the defendant. His testimony will not be used for him to opine that the defendant has mental issues per se, merely what he perceived the night of their interaction.
Okay, Ms. Pasculo, you get final word.
As so long as that the Officer Wentz is not testifying to anything anything more than just his observations that a layperson could observe, the prosecution is fine with that.
I think we're more or less all on the same page on this one. At least that's what it sounds like to me. I agree that Officer Wentz may not have the requisite training and experience to, for example, diagnose the defendant with a particular mental disorder. However, he is allowed to testify as to his rationally based perceptions. And so I think we're all on the same page on that. It's the motion to exclude is going to be granted in part to the extent that Officer Wentz is not, without more showing of qualifications, going to be allowed to diagnose the defendant. But it's going to be denied to the extent it seeks to exclude his testimony about the defendant's demeanor that night. Does that make sense?
Yes, Your Honor.
Yes,
Okay.
Your Honor.
Anything else from the state?
Not at this time, Your Honor.
Okay, for the defense, do we have any substantive motions to take up?
No, Your Honor. Defense is ready to proceed with opening statements.
Okay, very good. With that, prosecution, you may make your opening statement.
Yes, Your Honor. A moment to set up my second camera.
Certainly. And for the scoring judges, I'm going to switch to gallery view here, and I encourage you to do the same. Or excuse me, speaker view.
Your Honor, the prosecution is ready to proceed.
You may proceed when ready.
How to get rid of a body. Will bleach destroy a body? Countries that don't extradite for murder charges. These are the search terms that the defendant, Timothy Ray, put into his phone with his son's lifeless body just a short distance away. These are the search terms that the defendant entered into his phone to try and get away with murder. Nathan Ray was a 6-year-old. Members of the jury, my name is Adrian Ward, and together with my co-counsel, Victoria Pasquillo, we represent the state of West Carolina in this case. We will prove to you, beyond a reasonable doubt, the defendant, Timothy Ray, murdered his son, Nathan. Nathan Ray was a 6-year-old boy who liked Legos, drawing with crayons, and whose favorite cereal was Frosted Flakes. Wednesday, October 17th, 2018, started as a typical school day for Nathan. Nathan was having his favorite cereal for breakfast, doing what kids do when he made an innocent mistake. He spilled his juice, accidentally damaging his dad's work laptop. This, however, enraged his father, who decided to punish Nathan. First, the defendant began to yell at Nathan until Nathan started crying and ran to his room. Then, the defendant followed Nathan and ordered him to do strenuous physical exercises until given permission to stop. Nathan couldn't keep up and continued to cry, so the defendant went into his own room to think about how to punish Nathan further. Then the defendant took a belt from his dresser and returned to Nathan and began to hit him with it. Nathan wouldn't stop crying, so the defendant took his belt, put it around Nathan's neck, and pulled it tight until Nathan stopped moving, stopped crying, stopped breathing. Then the defendant attempted to dispose of the evidence and was only caught with the burial and the cleaning tools in the back of his car because he happened to be stopped at a police sobriety checkpoint. Detective Booth, the lead investigator in this case, will testify before you today. Detective Booth is a homicide detective and a career law enforcement officer born and raised here in Skelton. You will learn from Detective Booth that he arrested the defendant 2 days after the murder at a police sobriety checkpoint. You will learn that the defendant confessed to Detective Booth that he had murdered his son and tried to get away with it by burying the evidence. You will also learn that Detective Booth found the murder weapon in the defendant's home, as well as bleach, garbage bags, and a bloody shovel in the defendant's car. You will also learn that the detective and canine officers found Nathan Ray's 6-year-old body freshly buried in Brandywine State Park. Now, as you already know, and as His Honor instructed you again this afternoon, as the state, our burden is to prove the guilt of the defendant beyond a reasonable doubt. That means that we must show you, members of the jury, that the defendant caused the death of Nathan Ray either deliberately or with callous disregard for his life. The evidence will show you that the defendant thought about not doing it and then did it anyway. The evidence will show you that the defendant attempted to cover up his crime by cleaning the skin with bleach and burying his son in a shallow grave. Now, this case is a little different. We anticipate that everything I just told you is largely undisputed. So, why are we here? Why is there a trial at all? We're here because the defendant has asserted an insanity defense. Because the defense doesn't dispute that the defendant killed his son, they're going to try and convince you that he shouldn't be held responsible for his actions. Members of the jury, when I say convince you, I mean just that. It is the defense's burden to convince you that the defendant couldn't understand the difference between right and wrong, that the defendant couldn't understand the consequences of his actions because he was suffering from a bout of insanity that we anticipate the defense is going to attribute to schizophrenia, a disease the defendant has never been diagnosed with. The defense will be unable to meet their burden because their theory is not supported by the evidence. We will call an expert, Dr. Mac LaGreca, to testify to the defendant's mental health. Dr. LaGreca is an experienced psychiatrist who trains other psychiatrists. Dr. LaGreca will tell you that the defendant never exhibited symptoms of schizophrenia and that any symptoms he exhibited after the murder were merely a last-ditch attempt to get away with his crime. Members of the jury, well, you'll hear lots of medical terminology and expert testimony throughout today's trial. Don't leave your common sense at the door. Use your own common sense to see clearly what the evidence shows about the defendant's mental state. The evidence will show you that Detective Booth asked many questions of the defendant, and the defendant answered all of Detective Booth's questions coherently and candidly. That the defendant appeared to understand exactly what Detective Booth was asking him, and the defendant expressed remorse for murdering his son. When the defense tries to convince you that the defendant didn't know what he was doing, remember the three phrases the defendant searched for on his phone the day after the murder. How to get rid of a body, will bleach destroy a body. Countries that don't extradite for murder charges. The evidence shows that the defendant knew exactly what he had done and was desperate to do anything he could to get away with it. Now, at the end of this trial, my co-counsel, Ms. Pasquillo, will come before you. She will come before you to ask that you not let the defendant get away with it, that you hold the defendant accountable for the murder of his 6-year-old son, Nathan, that you reach the only verdict that the evidence supports, that you find a verdict of guilty of murder in the first degree. Thank you.
Okay, thank you, Mr. Ward. Does the defense wish to make an opening statement at this time?
Yes, Your Honor. Defense is ready to proceed with opening.
Okay, you may proceed when ready.
Your Honor, opposing counsel, members of the jury. When a parent kills a child, we ask why, how. When a parent kills a child, it's horrible. It's shocking, it's crazy, it's insane. When my co-counsel and I first heard about this case, we thought the same thing. How could a parent do that to their child? Until we met Timothy Ray. The evidence will show that Timothy Ray, he's not like you and I. He's different. So how, why? Well, we're going to tell you why today. Undiagnosed, untreated, and an unexpected tragedy. October 17th, 2018 did start out like any other school day. Timothy was fixing his son Nathan some breakfast, and everything was fine. Until all of a sudden, Nathan spilled apple juice. Now, remember a while ago how I told you that Timothy is a little bit different? Well, here's why. See, the evidence is going to show that voices suddenly started coming to Timothy. Now, this wasn't the first time the voices came. The voices had been coming for a long time, but today they came with a different message. So as soon as the apple juice was spilled, the voices came to Timothy and told him, you know he's trying to sabotage you, right? You know he's trying to sabotage you. And as Timothy tries to calm down and compose himself, he gets upset and he sends Nathan up to his room for punishment. But the voices keep coming, louder and louder and louder. And the evidence will show that the voices only got louder with a different message. Kill him, strangle him. And as Timothy tries to fight off the voices and sits down in his bed to try and compose himself, the voices just get louder and louder and louder. And that one thing that could make a parent lose it and kill their child happens. The voices come back and the evidence will show that the voices said, kill him, strangle him. And Timothy couldn't fight back any longer. Nathan was killed that day. But it is going to be clear to you, members of the jury, that it was not by Timothy. It was by schizophrenia that took not one, but 2 lives and forever changed this community. Now, a while ago, opposing counsel came up to you and made you a promise. They said that all of the evidence that they were going to put forth to you today, specifically that they have to prove that Timothy killed Nathan with premeditation and malice aforethought, they are going to have to prove that to you beyond a reasonable doubt. Let's talk about that. Beyond a reasonable doubt is the highest burden in our legal system. That is information and evidence that you will not even hesitate to rely on. So hold them to that promise. But let's say we get to the end of today's trial and you believe it. You say, okay, Timothy killed Nathan with premeditation and malice aforethought. Then defense asks you to consider the affirmative defense of insanity. Let's talk about insanity. You see, our legal system allows for insanity because unfortunately tragedy happens. But tragedy is not limited in the forms that it takes. And today you're going to learn that it took the form of schizophrenia. Schizophrenia, a horrid mental illness that when an individual is not in control of their mind and their body, tragedy happens. Now, in order to prove insanity to you, we must show you 2 things. First, Timothy suffered from schizophrenia on the day of the incident. And 2, because of that schizophrenia, he wasn't able to understand what he was doing. Now, to do that, we're going to prove that to you with 2 witnesses. First, you're going to hear from Officer Peyton Wentz, who is a rather new officer of Skelton. However, it's very important that you listen to Officer Wentz because Officer Wentz is someone who would normally testify for the prosecution, but they are here today to testify on behalf of Timothy Ray. And why is that? Officer Wentz is going to come up and tell you it's because he had never seen anything like this. Officer Wentz is the police officer that first saw Timothy at the checkpoint 2 days after Nathan's death. Now, during that interaction, at the beginning, everything is fine. Timothy is complying with Officer Wentz's orders, but all of a sudden, it changed. Timothy started accusing Officer Wentz of being in the CIA and started exhibiting other behaviors, and Officer Wentz had never seen anything like it. Then we are going to take what Officer Wentz explains to you, and we're going to talk about it with Dr. Shane Riley. Dr. Shane Riley is a longtime forensic psychiatrist. She served as a psychiatrist in the United States military, and she saw Timothy not once, but twice. She saw him once in 2010, and then again in 2019. And in 2019, Dr. Riley was able to have access to all of Timothy's records. She even conducted multiple interviews with other individuals about Timothy. Most of all, she is going to break down schizophrenia for us. She is going to tell us what schizophrenia looks like, how it's defined, and why Timothy has severe schizophrenia. She's going to explain to you what happens when schizophrenia goes undiagnosed and untreated, what the unexpected tragedy will look like. But then the prosecution is also going to have 2 witnesses. First, they're going to bring on Detective Blake Booth, who, yes, has served this community of Skelton for quite some time. However, Detective Booth, you're going to learn, knows Timothy, even before the incident happened. When Detective Booth saw Timothy, because their kids played soccer together at soccer practices, Detective Booth thought Timothy was dirty and unkempt and socially awkward. And when it was time for Detective Booth to conduct an interview with Timothy, he conducted the interview, and Timothy answered the questions all right. But Detective Booth didn't follow his directives, did nothing but cuss and yell at Timothy Ray, and still will come up to you today and explain to you what he believes Timothy did. Second, you're going to hear from Dr. McLaGreca. It is going to be clear to you that, yes, Dr. McLaGreca is knowledgeable in the field of forensic psychiatry. However, Dr. LaGreca simply didn't do enough. Dr. LaGreca did not conduct any interviews. Dr. LaGreca did no research. Dr. LaGreca did nothing but read reports and make an opinion. But at the end of the day, it's up to you, members of the jury, to weigh and balance the evidence. But I want you to remember the presumption of innocence, that every defendant who comes before you is presumed innocent until proven guilty. And today, the prosecution must prove that to you with the highest burden of our legal system. So hold them to it. Our hearts break with the Ray family on what has happened. However, it's important to remember that nobody benefits when someone is sick. So we ask the jury to help Timothy Ray. And at the end of today's trial, find Timothy Ray not guilty or not guilty by reason of insanity. Thank you.
Okay, thank you both. Now, before we proceed to the first witness, I'm going to ask everyone to switch to gallery view. That way you are able to see the attorneys and the witnesses testifying at the same time. And with that, the state may call their first witness.
Yes, Your Honor. One moment, please. Your Honor, the state calls Detective Blake Booth to the stand.
Okay. Good afternoon, Detective Booth. You are advised that you have been constructively sworn and placed under oath, and you have the obligation to tell the truth. Okay?
Yes, Your Honor.
With that, you may proceed, Mr. Ward.
Good afternoon, Detective Booth. Please introduce yourself to the jury.
Good afternoon. My name is Blake Booth.
What do you do for a living, Mr. Booth?
I am a detective for the Skelton Police Department.
How long have you been employed with the SPD?
23 years.
And how long have you been a detective?
8 years.
And to which unit are you currently assigned?
Homicide.
Now, Detective, how did you come to get involved in this case?
I was the lead investigator assigned to the murder of Nathan Ray.
Detective, how did you first get involved?
Received a call that a suspect in a missing persons case was apprehended at a evening sobriety checkpoint.
And who was that missing person?
A 6-year-old boy named Nathan Ray.
And who was that suspect at the police sobriety checkpoint?
Nathan's father, Timothy Ray.
Detective, could you please look around the courtroom, and if you see Timothy Ray, please identify him by an article of clothing?
Yes, I see him right there. He's wearing a gray suit.
Now, Detective, did you know who Timothy Ray was prior to his involvement in his son's murder?
I did, yes.
Did you know who Nathan Ray was?
I did, yes.
How did you know them?
Our sons went to the same school, and they played soccer together. Saw them both at soccer games a couple of times.
Now, Detective, bringing you back to the night of October 19, 2018, what, if anything, did you do once you learned that there was a suspect in a missing persons case detained at a police sobriety checkpoint?
Well, first I drove from my house down to the checkpoint.
Now, when you arrived, what did you see?
I saw the defendant in handcuffs sitting on the side of the road with his car pulled over on the side of the road as well.
Did you hear the defendant screaming?
No.
Did you observe the defendant thrashing about?
No, he was sitting upright on the side of the road.
Now, Detective, what, if anything, did you do at the scene?
Walked over to the defendant, and I told him that I needed to take him down to the station for questioning.
What was his reaction, if any?
He said, "I understand. I'll tell you everything." And then he started to cry.
Now, Detective, at this point, did he mention anything about hearing voices?
No.
Did he do or make you say anything that made you believe he needed psychiatric or medical attention?
No.
At any point, was he doing anything that you would consider abnormal?
Objection, Your Honor. Objection to speculation.
Okay, response to speculation, Mr. Ward?
Your Honor, the witness is just testifying to what he observed. There's nothing speculative about it.
Okay. Mr. Galvan, you want to respond to that?
Yes, Your Honor. If we may move outside the presence of the jury.
Absolutely.
Yes, Your Honor. Defense believes that because the question was to ask about anything abnormal, that is Detective Booth trying to make speculation about whether or not it was anything related to any kind of medical testimony.
My recollection of the question was more based on his personal observations. So the witness is instructed constructively to testify only as to his personal observations of the defendant's demeanor and to restrict his testimony to that. But the objection is overruled at this time.
Yes, Your Honor.
Yes, Your Honor. Now, Detective, did he do or say anything that made you believe he needed medical or psychiatric attention?
No.
And did he do or say anything that made you believe or that was abnormal to you?
No. He was just sitting there.
Detective, what did you do next?
I had him transported down to the police station so that I could interview him.
Once you arrived at the precinct, what did you do?
I Mirandized the defendant and asked him to sign a written Miranda waiver stating that he understood his rights, which he signed.
Was that interview recorded?
It was, yes.
Did you preserve that recording?
I had the audio transcribed, but the video was automatically deleted.
Why didn't you preserve the AV, Detective?
Well, because I preserved a statement in the transcript, and there wasn't anything about the defendant's behavior that required me to preserve the video.
Now, during this interview, what did the defendant tell you?
Told me that he murdered his son, Nathan, by strangling him to death with a belt in his home.
Did he explain why?
Yes. Mr. Ray said that his son had spilled apple juice on his laptop in the morning of October 17th, and that he had spilled the apple juice because his mother, the defendant's ex-wife, told him to. Mr. Ray then said he felt he had to discipline his son, which ultimately led him to him strangling his son.
Did he tell you how he attempted to discipline his son?
He did. First, he described that first he had the boy do jumping jacks. Then he made his son run in place while doing high knees. The defendant then told me that he went to his bedroom, grabbed a belt, and then went back to his son, began to beat him with the belt.
Did the defendant tell you what he did next?
He did. He said that his son told him that he hated him.
Your Honor.
Yes, what is the basis of the objection?
Hearsay within hearsay, Your Honor.
Okay. Mr. Ward, would you like to respond to hearsay within hearsay?
Yes, Your Honor. As far as the defendant's recounting of this to the detective, those are the statements of a party opponent. As far as the son telling the defendant that he hated him, we're not offering it for the truth of the matter. We're offering it for the effect on the listener to describe what the defendant did in reaction.
Okay. Mr. Galvan, do you want to respond to that?
Yes, I would, Your Honor. I would like to respond outside the presence of the jury.
Absolutely.
Your Honor, we do believe that this is being offered for the truth of the matter asserted, Additionally, it really does not go to the effect on the listener because Detective Booth is simply just, at this point, is just simply interviewing Timothy Ray. Rather, we believe that opposing counsel is offering this in order to prove the mental state of Nathan Ray. However, we're not here to talk about the mental state of Nathan Ray, which is why these statements should not be allowed in, Your Honor, under hearsay.
Okay. Mr. Ward, any response to that?
Your Honor, the Nathan Ray's statements are not being offered for the truth of whether or not he did in fact hate his father at that point, merely to illustrate for the jury what the defendant, why the defendant decided to do what he did next as he recounted it to Detective Booth.
Okay, thank you both for that argument. After considering it, I'm going to overrule the objection. You may proceed, Mr. Ward.
Yes, Your Honor. Detective, the question was, what did the defendant say he did next?
The defendant said that his son told him that he hated him. And,
Now, Detective, I'm sorry, continue.
Then the defendant took the belt, which he had used to whip his son. He wrapped it around the boy's neck and he strangled him until he died.
Now, Detective, did the defendant tell you what he did with Nathan's body after killing him?
Yes. He told me he put Nathan's body in his car before burying it in Brandywine State Park.
Directing court and counsel's attention to pages 57, 98, 99, and 106 would have been pre-marked for identification as exhibits 10, 21, 22, and 29. Detective, do you recognize these photographs?
I do, yes.
What are they photographs of?
Exhibit 10 is a screenshot of the defendant's phone search history. 21 is a crime scene photo from where we recovered Nathan's body in Brandywine Park. Exhibit 22 is a photograph of the items. It's a photograph of the defendant's backseat and the items that we discovered in the defendant's backseat. And 29 is a photograph of Nathan Ray.
Detective, how do you recognize these?
Exhibits 10, 21, 22 are photographs that I took during the course of my investigation. Exhibit 29 is a photo of Nathan. And I, as I mentioned earlier, I knew Nathan from my son's soccer games. The photograph of Nathan Ray was provided by Nathan's mother when she filed out the missing persons report.
Detective, are these photographs fair and accurate representations of the photo of Nathan Ray, the crime scene at Brandywine State Park, the backseat of the defendant's car, and his cell phone search history?
They are.
Your Honor, the state offers exhibits 10, 21, 22, and 29 in evidence at this time.
Okay, does the defense have any objections to exhibits 10, 21, 22, or 29?
Yes, Your Honor. First, with the for Exhibit 10, Your Honor, we object to hearsay on the entire document. As for 21, we also object to relevance under 403 only because we believe that this is substantially more prejudicial than probative, Your Honor, and believe that the statements could simply come from Detective Booth himself rather than statements that could possibly be considered inflammatory. And no objection to 22 or 29. Okay, so 22 and 29 will be admitted. From the prosecution, Mr. Ward, do you have a response to an objection of hearsay as to Exhibit 10 and an objection of substantially more prejudicial than probative as to Exhibit 21?
Yes, Your Honor, I'll address the hearsay objection to Exhibit 10 first. Now, as to the contents of the searches themselves, those are the statements of a party opponent. As to the hearsay, alleged hearsay of the screenshot, a screenshot is not a statement. The federal rules are very clear that hearsay applies to assertions made by persons. Furthermore, if there's any objection to the authenticity of the document, the parties agreed and stipulated to beforehand that all the exhibits are authentic.
Okay, and as to the 403 objection to the picture of the body.
Yes, Your Honor. The photograph of the body is highly probative of whether or not the defendant murdered his son, Nathan.
Okay. Mr. Gavon, would you like to reply to that?
Yes, Your Honor. I'd like to reply to both the hearsay and the 403 objection. Your Honor, to the hearsay objection, it cannot be an opposing party statement because the prosecution has not yet proved that Timothy is the one who made these actual searches. We understand that it was made on his phone, and we are not objecting or arguing against that it was found on the phone. We are simply arguing that it was not Timothy who actually made these searches. And because we have not heard any testimony that it was actually Timothy through any investigation or anything, it's not a party opponent statement. For the 403 argument, Your Honor, we believe that any statement about the photo is simply just to inflame the jury. Rather, Detective Booth could simply recount how the condition that the body was found.
Okay, thank you for that argument, both of you. After considering it, I'm going to overrule the hearsay objection as to the cell phone screenshots. However, I'm going to sustain the 403 objection to the depiction of the body in Brandywine State Park. I think Detective Booth can offer testimony on that in lieu of this photograph. So Exhibit 10 will be admitted. Exhibit 21 will be excluded. Okay?
Yes, Your Honor. Now, Detective, what did you take steps to corroborate the defendant's claim that he had killed his son?
Yes, we took several steps. First, we searched Brandywine Park and found Nathan's body there. Secondly, I obtained a warrant for the defendant's car and searched it. And third, I obtained a warrant for the defendant's smartphone and investigated the defendant's search history.
Now, Detective, you told us that you found the body of Nathan Ray. What condition was it in?
Well, we sent a canine unit into Brandywine Park. One of the dogs found the body, and the body was found inside a black garbage bag in a shallow hole, partially obscured by dirt.
Your Honor, permission to publish Exhibit 22 already in evidence.
Okay, you may.
Now, Detective, what did we just see in Exhibit 22?
We saw the defendant's back seat of his car. We performed a search of the defendant's car, and we found bleach, a dirty shovel with what appeared to be dry blood on it, and black garbage bags, all of which you saw in the photo.
Now, Detective, what, if anything, did the search of the defendant's cell phone do?
In the defendant's search history, we found 3 relevant searches.
Your Honor, permission to publish Exhibit 10 already in evidence.
You may.
Detective, what searches were you able to recover from the defendant's cell phone?
3 relevant searches made on October 18th. First, countries that don't extradite for murder charges. Second, how to get rid of a body. And third, will bleach destroy a body?
Nothing further, Your Honor.
Okay, Mr. Galvan, do you have a cross for this witness?
Yes, Your Honor.
You may proceed when ready.
Ready to proceed with cross. Detective Booth, I have a couple of questions for you. A while ago, you just testified on your direct about the Google searches, right?
That's correct.
And these searches were an investigation that was led and conducted by you, right?
Correct.
However, you can't say with 100% certainty that Timothy Ray was the one who in fact made these searches, can you?
They were searches made on the defendant's phone.
Well, that wasn't my question. I understand that they were made on the phone. However, my question to you is, Detective, you can't say with 100% certainty that Timothy Ray was the one who made those searches on that phone.
No.
Detective Booth, you knew Timothy before this incident happened, right?
That's correct.
In fact, a while ago, you just testified that you knew him because your kids played soccer together.
Correct.
And when you would see him at practices, you thought he was socially awkward, didn't you?
Yes.
And you also thought he was dirty and unkempt, right?
Generally unkept, yes.
Detective Booth, when you had the interview with Timothy, you had directives to follow, right?
Sure. The police department has a host of directives on how to conduct an interview.
So you have directives to follow, right?
That's correct.
And to help the jury understand directives, they're rather policies and procedures, aren't they?
They're guidelines, yes.
Guidelines to follow. And some of these guidelines is to record the interview, right?
Yes,
And you did request a transcript of the interview,
that's correct.
but you didn't request the audio recording, did you?
I didn't.
You didn't request the video recording either, right?
I did not.
And you had 30 days to request the audio and video, didn't you?
Yes.
But you didn't do that within 30 days, right?
No.
Detective Booth, Timothy told you what happened to Nathan, right?
He confessed to killing him, yes.
Yes, and because you knew Nathan, that made you angry, didn't it?
I just heard that a little boy was strangled with a belt, so I suppose yes.
So it made you angry, and you were also upset, right? Because you knew Nathan.
Well, not because I knew Nathan, no.
But it made you upset.
I don't think I don't think I was particularly upset, no, actually.
Well, but you were angry, and because you were angry, you called Timothy a piece of shit, didn't you?
I did say that, yes.
You called him a piece of shit in this official interview and told him he was better off dead, right?
I did, yes.
Would you agree with me that saying those things to an interviewee is not proper behavior by a detective?
Perhaps.
And you've been with the Skeleton Police Department for 23 years?
That's correct.
Detective Booth, part of your investigation, you worked with the missing persons report, right?
That's right.
And to finish it, you had to make a phone call with Jessica Ray, didn't you?
Yes, I did call Jess Ray after we found the body.
And you told her what happened to Nathan, right?
That's correct.
She was crying.
Your Honor, objection. Hearsay.
Okay, Mr. Galvan, do you have a response to hearsay?
Yes, Your Honor, if we may move outside the presence of the jury.
Certainly.
Your Honor, I'm simply laying the foundation and predicate for an excited utterance, Your Honor.
Okay. You can proceed to try to lay that predicate.
Yes, Your
All right.
Honor.
Overruled at this time.
Detective Booth, when you had that phone call with Jessica Ray, she was crying.
Correct.
She was sobbing uncontrollably, wasn't she?
Correct.
She was crying, sobbing uncontrollably, and she told you, I knew I should have never left Nathan with Timothy when he was acting so strange. I knew he was going crazy.
Correct.
Detective Booth, to become a police officer, you had to go through training, right?
That's right.
And you had training on how to interact with individuals who have mental health issues, didn't you?
In the academy, yes.
But you don't remember that training, do you?
It's 20 years ago, counselor.
So is that a no, you don't remember it?
I don't remember the specifics, no.
And you work out in the field?
I
Right?
do. Yes.
So you're working out in the field without remembering your mental health training? Is that correct?
I'm working on the field without remembering every single specific of my academy training from 20 years ago. That's correct.
Well, that wasn't my question. My question was, so you're working out in the field without remembering this particular training in mental health, aren't you?
Not the specifics. That's correct.
And because you don't remember your training, you wouldn't be able to know if an individual was exhibiting schizophrenia, would you?
I don't know if that's necessarily true. I can tell
Your
if
Honor,
someone's
I
acting
have to
crazy.
object at this time. This is asking for an improper label.
Response, Mr. Galvon?
Your Honor, I am simply asking the witness how his training would be able to affect how he acts and proceeds within the field, Your Honor. And this goes to the credibility of the witness.
Mr. Ward, would you like to have a final word on that?
Yes, Your Honor. That's not what opposing counsel asked. Opposing counsel asked whether or not Detective Booth would be able to diagnose or recognize someone with schizophrenia out in the field.
If I may respond, Your Honor.
Briefly.
I didn't ask whether or not he would be able to diagnose, but whether or not he would be able to notice signs because of his training. I'm simply asking about the training.
Right. I think the question was attempting to elicit a response of no, he's not qualified to answer that question. And so I don't think it's eliciting an improper opinion. I'll overrule the objection.
Yes,
Detective Booth, I'm going to ask you again. Because you don't remember that mental health training, you wouldn't be able to know if someone was showing signs of schizophrenia, would you?
I can tell if someone's acting crazy, counselor.
Well, that wasn't my question. Not acting crazy, but exhibiting signs of schizophrenia. Would you be able to know that without remembering your training?
Would I be able to know the exact mental illness of an individual on the field? Then no.
All right. While you were having the interview with Timothy, he accused you of being in the CIA, didn't you?
Didn't I?
Or didn't he?
What? He did, yes.
No further questions at this time, Your Honor.
Hey, Mr. Ward, would you like to redirect this witness?
No, the state does not need to redirect this witness.
Okay, then may he step down and be excused? All right, prosecution, you may call your next witness.
Your Honor, if I may, defense may have a second to switch rooms.
Certainly. Okay. Is everyone ready to proceed?
Yes, Your Honor. Thank you for that brief indulgence to switch.
Of course. State, you can call your next witness.
At this time, the state calls Dr. Mac LaGreca.
Okay, Dr. LaGreca, good afternoon. You are instructed that you have been constructively sworn and have the obligation to tell the truth. All right?
Mhm.
Okay, you may proceed when ready.
Good afternoon. Could you please introduce yourself to the jury?
My name is Dr. Mac LaGreca.
What do you do, Dr. LaGreca?
I am a doctor specializing in the field of forensic psychiatry.
Are you a licensed psychiatrist?
Yes, I am licensed in 3 states, including West Carolina.
Are you board certified in any areas?
Yes, I am board certified in forensic psychiatry.
Can you please tell us a bit about your educational background?
I earned a Bachelor of Science in Chemistry at the University of Delaware. Afterwards, I went to medical school at the Perelman School of Medicine at the University of Pennsylvania.
After finishing med school, did you participate in a residency program?
I did my residency in general psychiatry at the David Geffen School of Medicine at the University of California, Los Angeles. I then returned to the University of Pennsylvania to complete my forensic psychiatry fellowship at the Perelman School of Medicine.
What did you do after your fellowship?
I started my own private practice, La Greca Psychiatric Associates, where I worked for 23 years.
What do you do now?
I am program director of the West Carolina School of Medicine's Forensic Psychiatry Fellowship. I oversee the general psychiatry rotation for the medical students, and I treat patients once a week at the Jamie Spears Hospital, which is affiliated with the University of West Carolina.
Have you ever been an expert witness before?
Yes, 7 times in criminal cases.
And how many of these cases dealt with schizophrenia?
3 of them have dealt with schizophrenia.
Have you applied all of the principles and methods that you learned over the course of your career to the facts of this case?
Yes, I have.
How did you become involved in this case?
I was retained by the state of West Carolina to provide an opinion regarding Timothy Ray's mental health.
Did you rely on principles and methods that are standard in your field in arriving at this opinion?
Yes.
What materials did you review in coming to your opinion?
I used the DSM-5 and the joint exhibit list, which includes the summary of Major Riley's interview with the defendant that's contained in his report, and I also used materials and information referenced in my own report.
Were you able to come to an opinion to a reasonable degree of medical certainty?
Yes.
Your Honor, at this time, the state tenders Dr. La Greca as an expert in psychiatric examinations for the purposes of these proceedings.
Okay, does the defense have any reason or objection why the court shouldn't accept this witness as an expert in that field?
No, Your Honor. To clarify, it was in forensic psychiatry?
In psychiatric examination for the purposes of these proceedings.
We do object to that, Your Honor, as to vague.
Okay, that objection is going to be overruled. The court will accept this witness as an expert in the field of psychiatric examinations for the purposes of this proceeding. Okay.
Yes, Your Honor.
Hey, so Dr. La Greca, I want to talk to you now a bit about your evaluation. What is your opinion as to the defendant, Timothy Ray's mental health?
I concluded to a reasonable degree of medical certainty that the defendant was not schizophrenic and was in fact malingering.
How did you reach this conclusion?
For 3 reasons. First, there was no previous diagnosis of schizophrenia. Second, there was a lack of evidence or record of the defendant showing signs of schizophrenia in the past. And third, the defendant didn't show any symptoms during his interview with Major Riley, and any symptoms that he did show can be attributed to malingering.
All right, Dr. La Greca, let's take those one at a time. You mentioned that there has never been a previous diagnosis of schizophrenia. What is the significance of a diagnosis of schizophrenia in a case as such?
Without a previous diagnosis, you have to make the diagnosis based on the person's symptoms manifested after the fact. And when there is no diagnosis or documentation of symptoms before an incident, it increases the likelihood that someone is malingering.
How is schizophrenia diagnosed?
By determining whether the person shows the symptoms laid out in the DSM-5.
And what is the DSM-5?
It's a manual for the assessment and diagnosis of mental disorders, and it's published by the American Psychiatric Association.
How do you know that the defendant has never been diagnosed with schizophrenia?
Because there is no mention of schizophrenia in any of his medical records by the 3 doctors who evaluated him, who were Major Riley, Dr. DiGiuseppe, and Dr. Narasimhan.
What was the result of when those 3 doctors evaluated the defendant?
Major Riley diagnosed the defendant in 2010 with general anxiety disorder, not schizophrenia. Dr. DiGiuseppe saw the defendant between 2010 and 2017, and she never diagnosed him with any mental illness or prescribed him any medication. And Dr. Narasimhan saw the defendant on November 12, 2019, after the defendant had killed his son. Dr. Narasimhan also made no diagnosis and only prescribed medication for depression and anxiety.
Was the defendant ever hospitalized for schizophrenia?
He was only once hospitalized in 2010 for anxiety and depression due to his military-related stress.
What was he diagnosed with then?
General anxiety disorder.
And who diagnosed the defendant?
Major Riley, the defense's expert.
Okay, Dr. LaGracca. So now I want to turn to that second reason that you had mentioned previously as to why you diagnosed the defendant as such. You mentioned that there was no evidence that the defendant was displaying symptoms of schizophrenia in the past. How did you determine that?
I looked at his medical records, his employment history, education history, interviews of his relatives and boss. I also looked at his criminal history, his interactions with law enforcement officers, and his account of the actions before and after killing his son.
And according to the reports and all of the records you reviewed, is there any evidence that the defendant heard voices prior to his clinical interview on September 8, 2019?
No. In fact, the defendant outright denied experiencing those symptoms to Major Riley in 2010.
Based on your review, did the defendant have any hallucinations, whether visually or auditorily, prior to his clinical interview on September 8, 2019?
No.
And based on this same review, did the defendant experience delusions prior to September 8, 2019?
No.
What, if anything, about the defendant's employment history affected your opinion?
He worked at an electronics repair company for 8 years. And over the 8 years that he worked there, he was never formally disciplined. And in fact, his boss told Major Riley that Timothy Ray was a fantastic employee. And this is weird because those with schizophrenia tend to have difficulty maintaining employment, and the defendant did not have any difficulty doing that.
What, if anything, about the defendant's educational background affected your conclusion?
He graduated from Skelton University, receiving a bachelor's degree in computer sciences, and he graduated summa cum laude. And those with schizophrenia tend to have difficulty completing education.
What, if anything, about the interviews that were conducted of family members and close acquaintances affected your conclusion?
Interviews with the defendant's family conducted by Major Riley did not indicate that the defendant exhibited any symptoms of schizophrenia, nor the defendant telling them about those symptoms. This is unusual because schizophrenia tends to be ongoing, with the onset of the first psychotic episode for males manifesting when the person is in their early to mid-20s.
Okay, Dr. LaGracca, now I want to turn to that third reason that you had mentioned that led to your conclusion. You said that it was that the defendant didn't show any symptoms, that any symptoms he showed during the interview was actually malingering. So when did this interview with Major Riley take place?
It took place on September 8, 2019, after the defendant had already killed his son.
Was there any record that the symptoms that the defendant reported to Major Riley during that interview were ever observed by family or friends?
No.
Were the overwhelming majority of the symptoms that the defendant reported to Major Riley during this clinical interview ever documented in employment, military, or medical records?
No.
How old was the defendant during this clinical interview?
32 years old.
Is it unusual for someone, or for rather a schizophrenic, not to show symptoms until age 32?
Yes. According to the DSM-5, the peak age of onset for the first psychotic episode is in the early to mid-20s for males.
The defendant your opinion is that the defendant is not a schizophrenic. So how do you explain the defendant's self-reported symptoms to Major Riley during that clinical interview?
The defendant is likely malingering.
What is malingering?
Malingering is when one is faking symptoms, often to create a legal defense.
And how do you know if someone's malingering?
The DSM factors for malingering include the legal context of a clinical assessment and discrepancies between the person's claimed psychiatric disorder and objective findings. And then third, failure to cooperate during diagnostic evaluation and failure to comply with treatment.
Are there any factors outside of the DSM-5 that are considered when determining whether one is malingering?
Yes, other factors need to be considered as well, including evading criminal prosecution and other such incentives.
Did the defendant display any of the DSM-5 symptoms of malingering?
Yes, he showed 3 of the 4 DSM symptoms of malingering based on by me applying the DSM factors to the facts of the case. First, Major Riley's assessment occurred in the context of a criminal evaluation. Second, there exists major discrepancies between the symptoms described by the defendant during the clinical interview and the symptoms, or rather lack thereof, documented in the written materials, including medical records and described by those who knew him best. Major Riley also noted that there were inconsistencies in Timothy Ray's account of October 17, 2018, the day of the killing. Finally, the defendant was not cooperative with Major Riley during the interview.
Your Honor, may we approach?
You may.
So at this time, I would like to ask Major Riley whether anything that the defendant said to Major Riley indicated that he would have a strong incentive to malinger. This was the question that, or rather, I anticipate that the response to this will be what we discussed in the motions in limine regarding the potential that Major Riley, I apologize, Dr. LaGreca will be discussing the jail statement that the defendant made.
Okay. A response from Ms. Ledesma?
Your Honor, if we may hear that statement one more time, what the statement will be. Mind you, Your Honor, are we constructively outside the presence of the jury?
We are.
May we hear the statement one more time, Your Honor?
Would you like me to read it, Your Honor?
Certainly, thank you.
I'd like to direct court and counsel to page 62 of the electronic notebook. And I'm reading from the 3rd paragraph, more towards the end of the center, but more towards the end. He expressed fear at times, indicating, quote, that he knew he was going to jail for what he did. Dr. LaGreca is going to find that read back that statement or something similar and say that that is one of the reasons why the defendant may have had a strong incentive to malinger.
Okay, Ms. Ledesma, do you have a response?
Yes, Your Honor. We re-urge our objection earlier as to it goes to 704B because this is an expert witness and because the ultimate issue in this case is whether the defendant had the requisite mental intent to kill his son. And if I may briefly explain a little more into that, Your Honor.
Sure.
So we understand it that the state is allowed to use circumstantial evidence to go ahead and help prove their case, prove that the defendant had the requisite mental intent, Your Honor. We urge that this statement would actually, especially coming from the defendant, even though the state is saying it falls under malingering, it actually goes to the ultimate opinion in today's case because of the burdens that we are talking about today.
Okay, Ms. Pasculo?
Yes, Your Honor. Under 704B, the experts are allowed to offer their opinion on whether or not the defendant had or has schizophrenia. They're similarly entitled to offer their opinions as to whether or not the defendant was or was not malingering. An opinion on malingering is not testimony to the actual issue, but rather just a counter as to whether or not the defendant was schizophrenic.
Your Honor, if we may.
Briefly.
The state has already provided evidence regarding this expert's testimony as to why she believes the defendant is malingering. This statement in particular, Your Honor, is being used as a backdoor to have an expert testify as to the ultimate issue in today's case.
Okay, thank you for that argument from both of you. It's very thoughtful and helpful to the court. And at the risk of showing my work a little bit for the appellate court, I'm going to say that I don't really have concerns about 704B with this particular testimony. My concern pre-trial was more with regards to mentioning potential penalties in the guilt innocence phase. And I think the statement as written in this report, just that he didn't want to go to jail, he knew he was going to jail, I don't think that's harmful error on that issue. And so, Ms. Ledesma, your objection is noted for the record, and you have preserved any error. And Ms. Pasculo, I'm going to overrule the objection. You may proceed to elicit that testimony. Okay?
Yes, Your Honor.
Yes, Your Honor. All right. Dr. LaGreca, was there anything that the defendant said to Major Riley that indicated that he had a strong incentive to malinger?
Yes, he's expressed fear at times, indicating that, quote, he knew he was going to jail for what he did.
Are there any other factors that indicate the defendant was not schizophrenic and was rather malingering?
The defendant attempted to hide evidence of the crime. His internet search history, which
Objection,
include
Your
things
Honor.
like,
Yes,
Your Honor, if we may be heard outside the presence of the jury constructively.
constructively approached.
Your Honor, we understand that the Google searches were talked about and discussed with Detective Booth. However, under 403, Your Honor, this evidence, whatever probative value it had with Detective Booth, is now substantially outweighed by its prejudicial effect, as well as the fact that it will most likely confuse the jury, Your Honor, seeing as the state has not been able to provide any testimony that the defendant himself made these Google searches, as well as no other witness will be able to testify to that fact.
Response?
Yes, Your Honor. Exhibit 10 is already in evidence. Both experts have been in the courtroom for the entire proceedings here. Additionally, the prejudice does not substantially outweigh the probative value. This was one of the materials that both experts reviewed to come to their conclusions. Here, Dr. LaGreca, this is one of the factors that she used to determine that the defendant was not schizophrenic and was rather malingering. Goes directly to the opinion of the expert.
Your Honor, if we may.
Briefly, yes.
These Google searches, Your Honor, likewise are being used to testify that the defendant is malingering. However, since nobody will be able to testify, nor have they been able to testify that the defendant himself made these Google searches, Your Honor, it doesn't connect that they should be factored into whether the defendant himself is malingering.
Okay, thank you both. I think the 403 objection to the exhibit would have been well taken if it was made previously. The only objection that was made to Exhibit 10 previously was hearsay. That was overruled. However, I do think that Ms. Ledesma, your co-counsel, made that point about verifying who made the searches on cross-examination. You're welcome to make that point on cross-examination of this witness as well. And with that, objection overruled.
Yes, Your Honor.
Dr. LaGreca, I'm going to ask you that question again. Was there anything else, any other factors that indicate the defendant was malingering and not schizophrenic?
the defendant attempted to hide evidence of the crime, his internet search history, which included things like countries that don't extradite for murder charges, how to get rid of a body, and will bleach destroy a body. Only hours after the killing, plainly indicates his consciousness of guilt, which is further evidence of malingering.
Objection, Your Honor.
Yes.
704B, the witness just testified that the defendant had a consciousness of guilt. As we've discussed previously, the ultimate issue in today's case is whether the defendant was aware of his actions and was aware that they were wrongful.
Response, Ms. Pasculo?
Your Honor, from my understanding, the witness had just testified as to whether or not about these searches and whether or not they showed that he was malingering, not whether or not he, to the ultimate issue of this case.
Your Honor, if I may.
Yes, you may.
The expert herself just testified that he indicated consciousness of guilt, Your Honor, meaning that the defendant understood what he was doing and that he knew it was wrong, which violates directly 704B as well as the local rules within our jurisdiction.
Okay. Yes, thank you for that argument. And I pulled up the case law that we have on this issue in this jurisdiction, Pasquarello versus West Carolina, to make sure I'm correct on this. I believe that the objectionable opinion as to the ultimate issue would be specific as to the time of the alleged crime. But I do not believe that precludes this expert from giving testimony about awareness of guilt after the crime, such that it would be used as circumstantial evidence of the defendant's state of mind at the time of the incident in question. So you can consider that I'm constructively instructing the jury that that is the ultimate issue that they are to decide, specific to the time of the incident, and that this expert is not opining as to that. And with that limitation, I'll overrule the objection.
Yes, Your Honor.
And Dr. LaGreca, so based on all of this that you reviewed, what was your ultimate opinion as to whether or not the defendant was malingering?
My opinion is that the patient was not schizophrenic and was in fact malingering.
Thank you. I have no further questions.
Ms. Ledesma, do you have a cross-examination for this witness?
Yes, Your Honor, we do. 1 second.
Certainly.
Good afternoon. I'd like to start with talking about schizophrenia. The DSM-5 notes that some symptoms of schizophrenia may be prevalent when others are not. Correct?
Yes,
So it's possible then, doctor, that somebody may be 22, have schizophrenia, but not be medically diagnosed with schizophrenia until they're 23.
that's correct.
It's possible that somebody may have schizophrenia when they're 29, but not be medically diagnosed with schizophrenia until they're 32.
That's correct.
Now, I'd like to talk a little bit about the Google searches you were discussing on direct examination. You cannot testify today that the defendant himself made those Google searches, correct?
That's correct.
And out of the 3 Google searches you reviewed, not one of them asked how to fake a mental illness, correct?
That's right.
Now, I'd like to talk a little bit about malingering. On direct examination, you stated malingering is someone faking, or can be defined as someone faking a mental illness in order to receive some perceived benefit.
I said something like that.
And you identify that this is that faking a mental illness is primarily seen with people who have been charged with crimes.
Yes,
Now, generally speaking, doctor, anybody who's charged with a crime and describes having a mental illness is usually evaluated for malingering, correct?
that's right.
But we can agree that not everyone who's charged with a crime and describes having a mental illness is faking a mental illness.
That's right.
Now, I'd like to talk a little bit more about the basis of your opinion today. Starting with symptoms associated with the DSM-5. Childhood trauma is a feature or symptom that indicates someone is more likely to develop schizophrenia.
Yes, but it's not part of the diagnostic criteria for schizophrenia.
That's right, but it's associated with someone potentially developing schizophrenia, correct?
That's correct.
Now, anxiety is listed in the DSM-5 as an associated feature of schizophrenia.
Yes, it is an associated feature.
We can also agree that hostility and aggression are associated features of schizophrenia.
Yes, but they're not specific to schizophrenia.
But they're associated with schizophrenia.
They are associated.
We can also agree that the DSM-5 notes impairment in self-care and interpersonal relations as indicative of schizophrenia.
That's correct, But again, these things by themselves do not point to necessarily a diagnosis of a severe mental illness.
Okay, well, we'll get to that, doctor, but one other or two other symptoms associated with schizophrenia are delusions and hallucinations, correct?
That's correct.
Now, I'd like to talk a little bit about the materials you reviewed in today's case. You testified on direct examination that you reviewed all of the materials in Dr. Riley's report and all the materials reviewed in your report, as well as Dr. DiGiuseppe's, correct?
That's correct.
Now, one of the reports you reviewed indicated that Tim had experienced childhood trauma.
That's correct.
You reviewed a report showing that Tim had experienced anxiety.
That's right.
In fact, Tim was diagnosed with general anxiety disorder back in 2010.
That's right.
You reviewed a report showing that Tim had a violent and physical altercation at work.
Yes.
And violent physical altercations can be representative of hostile and aggressive behavior.
Yes.
You reviewed reports indicating that Tim was going more than a week without showering.
Yes.
You reviewed reports indicating that Tim was having trouble sleeping.
That's correct.
You reviewed reports that Tim was isolating himself more and more throughout the years.
Yes.
You reviewed reports that Tim would lock himself away from hours on end.
Yes, I did.
You reviewed reports showing that Tim was always having difficulties with mood swings.
Yes.
You reviewed reports showing that Tim would be fine one moment and then crying the next minute.
Yes, I did.
You reviewed reports that Tim had become a completely different person before his wife left.
Yes.
Now, and someone isolating themselves, not showering for more than a week at a time, locking themselves away for hours on end, having trouble with mood swings, and becoming a completely different person within their marriage are indicative of somebody experiencing impairment in self-care and or an interpersonal relationship.
That's right.
Now, you also reviewed reports showing that Tim was seeing things nobody else could see and hearing things that nobody else could hear.
Yes, and I believe the majority of that came from his interview with Major Riley after the killing.
The interview happened after the killing, but these reports and when the symptoms occurred were reported as before the killing, correct?
I'm sorry, can you rephrase that?
Yes. So the interview occurred after the killing,
Yes.
but the reports within the interview were regarding times before the killing occurred.
That's right.
Seeing things that nobody else can see and hearing things that nobody else can hear are indicative of someone experiencing hallucinations.
Yes, but in this case, the only other person who thought Timothy Ray was having hallucinations was his commanding officer, which Major Riley admitted himself that he was known for spinning the truth.
Well, let's talk a little bit about hallucinations then, doctor. So you're saying the only reports of hallucinations came from somebody who's not here to testify today?
Well, two, aside from Major Riley.
And to clarify, the defendant had an interview with Dr. Riley, correct?
Yes.
And in this interview, the defendant himself was the one reporting these symptoms of hallucinations.
Yes.
And we've already agreed that seeing things that nobody else can see and hearing things that nobody else can hear are representative of someone experiencing hallucinations.
Yes, but I'm saying that the majority of those allegations came during his interview with Major Riley.
Yes, but we can agree that those were present in the record that you reviewed.
Yes, as I mentioned, that one instance with Officer Cruz.
And you also reviewed reports that the defendant was accusing people of listening in on his phone calls.
I did.
Now, believing that somebody is listening in on your phone calls may be representative of a person experiencing delusions.
It's likely, but it's not the only explanation.
But it's likely.
It's likely.
I would now like to instruct my tech advocate that he may remove the demonstrative from the screen. Now, to clarify, Dr. LaGreca, those reports and observations primarily regarded behaviors of Tim from his early 20s to his early 30s.
Yes.
And the DSM-5 notes that schizophrenia may develop anywhere between someone's mid-teens to their mid-30s.
That's right.
So to clarify further, the observations and reports in this case reflect symptoms associated with schizophrenia within the age range that schizophrenia may develop.
Yes, but my concern was there was a lack of such evidence in the materials presented.
A lack of such evidence. Even though we agreed that you reviewed reports indicating Tim experienced childhood trauma, anxiety, hostility and aggression, impairment in his self-care, impairment in his interpersonal relations, delusions, and hallucinations. Those were not present in the record.
Objection, compound.
If the witness is able to understand the question, she can respond.
So first off, I didn't explain why I don't think he had delusions or hallucinations. And also the other things that you mentioned, anxiety, depression, childhood trauma, those are merely contributing factors to somebody getting schizophrenia. But like I said, they by themselves do not point necessarily to a severe mental illness.
And I agree with you, doctor, but those symptoms were not by themselves, were they? We agreed that all of those symptoms, childhood trauma, anxiety, hostility and aggression, impairment in self-care, impairment in an interpersonal relationship such as a marriage, delusions and hallucinations, all together were present within the record.
Overruled.
Can you rephrase that question?
We can agree, we've already agreed that childhood trauma and anxiety were not present alone in this record, correct?
Yes, and I didn't disagree with those things that you mentioned. What I had issue with were the delusions and hallucinations.
But we've agreed that Tim was reporting seeing things that nobody else could see and hearing things that nobody else could hear.
Yes, in his interview with Major Riley after he was arrested.
And we've also agreed that Tim was accusing people in his life of listening in on his phone calls.
Yes, that was a one-time incident.
But it happened.
Around.
But
yes.
It happened. I don't want to cut you off. That's why I paused.
Oh, okay. Yeah. I'm sorry, I lost my train of thought. Can you repeat the last part?
The delusions that you reviewed in today's report occurred where Tim was accusing people of listening in on his phone calls.
Yes, that was a one-time incident and around when he was having a lot of marital issues.
To be clear, this statement was made in 2016, 2017?
Yes.
Jessica Ray did not leave him until late 2018.
Yes, but I also believe in 2014, he was reporting marital problems.
In 2014?
Yes, in 2014, he was having difficulty with with his marriage. In fact, I think it was Jessica Ray who told him to see the physician.
And we agreed that those delusions we discussed earlier were in 2016, 2017, correct?
Yes.
Which would have been 2 to 3 years after that last visit.
I'm sorry, what delusions and hallucinations are you referring to again?
The delusions and hallucinations, doctor, that Tim was seeing things nobody else could see, hearing things that nobody else could hear, and reporting or accusing people of listening in on his phone calls.
And what about them?
Those occurred before he was charged with the crime.
According to him, yes, they occurred.
No further questions at this time, Your Honor.
Okay, is there any redirect for this witness?
No, Your Honor. The state
All right.
rests.
Then she may step down and be excused. And Ms. Pasculo, unless I misheard you, I think you just said the state rests.
Yes, Your Honor.
Okay. Defense, is there any matter we need to take up outside the presence of the jury before we proceed further?
Yes, Your Honor. The defense does have a mid-trial motion. If I may switch with my co-counsel briefly.
Certainly.
Your Honor, at this time, defense would like to make a motion outside the presence of the jury.
They are constructively removed.
Yes, Your Honor. Under the Federal Rules of Criminal Procedure, defense motions for a movement of acquittal as per the Federal Rules of Criminal Procedure, Your Honor, and this is because the prosecution has not met its burden today. You see, in their case in chief, all the prosecution did was simply focus on whether or not Timothy had schizophrenia at the time of the incident, which actually goes to the defense and our burden in our case in chief. There were no other statements except for the one about Timothy sitting on his bed to combat the first-degree murder elements, Your Honor. So therefore, defense moves for acquittal.
Okay, Mr. Ward, do you have a response?
Your Honor, in a light most favorable to the state, the state has elicited through the testimony of Detective Booth that he found physical evidence tying the defendant to the murder. Moreover, the testimony of Detective Booth indicated that the defendant went into his room and thought about what he was going to do before he did, in fact, murder his son. That satisfies the element of malice aforethought or premeditation. A reasonable juror could most certainly conclude with that testimony alone that the defendant did, in fact, murder Nathan Ray.
Okay, Mr. Galvan.
Your Honor, again, we've only heard one statement that Timothy Ray sat on his bed and reflected, which is not enough in order to prove malice aforethought and premeditation for murder. Your Honor, defense does not believe that the state has met its burden and again moves for a judgment of acquittal.
Okay, gentlemen, thank you for that argument. The motion for acquittal is denied without prejudice at this time. And with that, I think it'd be best if we gave our jury a 5-minute break before we proceeded to the defense case in chief. I have it as approximately 5:55 Eastern time. And so why don't we plan to be back here at 6 o'clock Eastern? Okay?
Your Honor, if I may.
Yes.
Before the defense proceeds with their case in chief, could we get a time check for both the parties?
I think that'd be a great thing for the timekeepers to do over the break.
Yes, Your Honor.
Thanks. Okay. I have that we still have 14 participants, so that's good. We didn't lose anybody. Do we have the advocates ready to proceed?
Yes, Your Honor. I'm here. I'm not sure about co-counsel.
Okay, we'll make sure everybody gets back before we proceed further.
Co-counsel. Sorry to interrupt, Your Honor. The state is ready to proceed.
Okay. Do we have the attorneys for the defense? I believe you're muted. There you go.
We got it. Yes, Your Honor, we are ready to proceed with our first witness.
Okay, then you may proceed with your case in chief when ready.
At this time, Your Honor, the defense would like to call Officer Wentz to the stand.
All right, good evening, Officer Wentz. You are instructed that you have been constructively sworn and have the obligation to tell the truth.
Yes, Your Honor.
You may proceed.
Good afternoon, Officer Wentz. Could you please introduce yourself to the court?
Yes, my name is Officer Peyton Wentz of the Skelton Police Department.
How long have you been an officer with the Skelton Police Department?
As of today, it's about 4 years.
What type of training did you receive in order to become an officer for the Skelton Police Department?
I received all of the normal academy training as well as a special mental health program called CIT, Crisis Intervention Team, that dealt with recognizing people that have mental health issues like psychosis and schizophrenia.
Now, Officer Wentz, I'd like to talk a little bit more about how you first interacted with the defendant. What were you doing when you first met Timothy Ray?
I was working at a routine sobriety checkpoint when the defendant's vehicle approached. I walked over to the car, asked him to roll down his window, but I could tell something was off from right away.
Now, just to move backwards a little bit, Officer Wentz, since you work this checkpoint often, have you seen drivers before who appear angry?
Yes,
Have you seen drivers before who appear upset?
yes,
Have you seen drivers before who appear to be under the influence?
yes.
How did the defendant appear to you when you first interacted with him?
Well, as soon as I got to the car, I could tell he was disheveled. His hair was a mess. His eyes were glassy. He had an overwhelming body odor. His clothes were dirty, and it looked like he'd been, his car had been slept in for a couple days.
Your Honor, may we approach?
You may.
So it's still a few questions off. However, we would like to take some time out of respect for the court to acknowledge that Officer Wentz will be getting into testimony. In his previous interview with Detective Booth, he has identified a question that the defendant asked as crazy, and we would like to talk about that now before any testimony is elicited, and it's already in front of the jury.
Okay. What is the specific testimony that you're going to seek to elicit with this witness?
So the question itself is, are you with the CIA? However, when Officer Wentz describes this question, he has previously qualified it as crazy, Your Honor, which is why we are bringing this to the court's attention at this moment.
Okay. Ms. Pasculo, I think they are being cautious and not wanting to violate any motions in limine. Do you agree or disagree that the witness making a statement about something as crazy violates the motion in limine?
Yes, Your Honor. It does violate the motion in limine. Crazy is a synonym for insane, and the whole defense that the defense is putting on is an insanity defense. It has the possibility, and the use of the word it can confuse the jury and lead them to believe that that Officer Wentz observed the defendant as being insane at the time.
Ms. Ledesma, do you have a response?
Yes, we do, Your Honor. Now, the word crazy is a word that we would normally use as non-medical experts to identify behavior that is abnormal, or something we're not used to generally in observing. No medical professional, however, would medically qualify someone as crazy. The proper word would be insane or some medical diagnosis regarding a specific mental illness, but they would not use the word crazy. And because pursuant to the local rules in which this trial is being held, it's an expert testimony, Your Honor, is not being elicited from this witness. We are merely eliciting testimony to help the jury evaluate and understand why this officer in particular is testifying today as to what he saw the night he first interacted with the defendant.
Ms. Pasculo, I'll give you final word on this.
Your Honor, again, we're fine with the defendant, with Officer Wentz testifying as to what he observed. However, we are not fine with the use of the word crazy. Again, that's a classification that is closely linked to insanity. Even if it's being used in the vernacular, there are ways that crazy, unfortunately, sometimes in society, a mental house is referred to as a mental hospital is referred to as a crazy house. It has a very close relation to the word insanity, which is the reason why they were able to bring an expert. We both brought in an expert, and so did the defense. I anticipate that they will be bringing in an expert as well. So they could have the expert testify as to whether or not the defendant was insane at the time, but to have an officer who is not a medically trained professional and is prohibited under 701C is not, we don't agree with that.
Thank you. And I appreciate your concerns, both of you, in that argument. It's helpful to the court. Here's what my ruling is. My ruling is, Ms. Ledesma, you can ask the witness what he characterized that statement about the CIA as in his own words, as long as you make it explicitly clear that he is not a medical professional or psychiatric professional and is not qualified to diagnose the defendant, nor was he attempting to do so. And if you don't make it explicitly clear, I will instruct the jury myself, and I guarantee you will not like my instruction better than your questions. Okay?
Yes, Your Honor. But before we move back inside the presence of the jury, to clarify, would you like us to lay this predicate prior to the testimony, or is it fine after the testimony?
That I will leave up to you, as long as there is no doubt about the line of questioning that he is not making a medical diagnosis.
Yes, Your Honor. We understand.
You may proceed.
Now, Officer Wentz, based off the description you just gave of the defendant, how did you proceed to interact with Tim?
Well, I asked for his license and registration like I asked for everybody. He kind of argued with me, but eventually I got his identification, but I thought, he was acting pretty odd.
Why do you say odd?
Well, because of the questions that he proceeded to ask me.
Well, Officer Wentz, let's talk a little bit more about that. How would you characterize the questions he proceeded to ask you?
Well, I thought they were crazy. They sounded crazy to me.
Well, Officer Wentz, can you describe for the court what those questions were?
Yeah, he first asked me, "Are you with the CIA?" And then he said something like, I know the CIA is after me. And then he said something that they think I'm a terrorist, something along the lines of those.
Now, Officer Wentz, to be clear for the court and the members of the jury, are you a medical professional?
No, I'm a police officer.
Have you ever received university medical training?
No.
Have you ever practiced in the medical field in any way, shape, and or form?
No, I haven't.
So your testimony today is not based off of any medical experience and or training you may or may not have received.
That's correct.
Now, Officer Wentz, after the defendant asked you if you were working with the CIA, how did you proceed to interact with him?
Well, I told him I'm a skeleton police officer. I pointed to my badge, but then, he kept on asking me these questions. So eventually I asked him to step out of the vehicle.
So from inside the vehicle to now outside the vehicle, Officer Wentz, what was the defendant's behavior like at this point?
Well, when he got out of the car, he seemed like he completely changed. He was moving very slowly, like a zombie. He was muttering to himself. It was very different than when he was inside the vehicle, where he was asking me these questions, very quickly and very frantically.
How did you continue to interact with the defendant after his behavior was now zombie-like?
Well, I was a little taken aback because I'd never seen anything like this before. But, he then proceeded to do a jumping jack. And at that point, I instructed him to stop doing jumping jacks, to stop moving like that.
Well, how did the defendant respond to your instruction to stop doing jumping jacks?
I don't know if he didn't hear me or, he heard me and was ignoring me, but he then did another jumping jack. And at that point, I pulled out my gun and I again instructed him to stop moving.
How did Tim react to that?
Well, he stopped doing a jumping jack, but then he put his hands over his ears and began to move his head around uncontrollably. And at that point, I moved in to restrain him with my handcuffs and I took him to the ground.
Officer Wentz, at this point in time, did you know that Timothy Ray was a suspect in a missing persons report?
No, I later learned that from my partner who ran the Timothy Ray's license and registration through the computer.
No further questions at this time, Your Honor.
Okay, thank you, Ms. Ledesma. Ms. Pisculo, do you have a cross-examination for this witness?
Yes, Your Honor.
You may proceed.
All right, good afternoon, officer.
Hello?
All right, so the defendant was stopped during a routine traffic stop.
That's correct.
And you agree that you didn't stop him because he was swerving?
No, that's correct.
He wasn't driving erratic?
No.
You would describe the defendant's behavior when you first approached him as defiant, correct?
Yeah. Yes, I would.
And the defendant initially refused to give you his license and registration until after you pointed out his wallet, correct?
That's correct.
Right, officer, I'd like to direct your attention now to what you saw in the defendant's car. When you looked through the back seat of the defendant's car while pointing your flashlight, you saw a shovel in the back seat.
Yes.
It appeared like the shovel had blood on it.
What I believe to be blood at the time, yes.
And you also saw 2 jugs of bleach.
Yes.
There were multiple black garbage bags as well, correct?
Yes.
And you gave the defendant's license and registration to your partner to run?
Yes.
And it's then that you returned back to the defendant's vehicle, correct?
Yes.
Right, officer. I want to talk to you now about what happened when you returned to the defendant's car after giving the license and registration to your partner. You returned to the driver's side window, correct?
Yes.
And it was not until you walked the defendant's license and registration to your partner and then returned to the defendant's car that he started talking about the CIA, correct?
That was the order of events, yes.
When the defendant got out of the car, he said that he was just trying to get his son in shape and get him to admit what he broke, correct?
I believe he said that.
He said he was also a good father, right?
Yes, I believe he said that too.
Right. And you're an officer in the traffic unit,
Yes, I am.
and you've only been a police officer for 2 years.
At the point, when I was with the defendant, it was 2 years. Now it's 4 years.
Right. So 2 years at the time of the stop, correct?
That is correct.
Okay. And you agree, as you testified on direct, that you're not a mental health expert or have any advanced training in that, correct?
Besides that CIT training at the academy, no.
But you don't have a medical degree, correct?
Nope.
Right. So, officer, I want to direct your attention to after you put the defendant in handcuffs. You learned that this defendant was a suspect in a missing persons case?
Yes, I think I was informed of that by my partner.
And at that point, you called in the case.
Yes. Well, I called in what I saw.
I'm sorry?
I called in what I saw that night.
And you didn't request an EMT explicitly, correct?
No, I didn't request that. I just told him what I saw.
The defendant was talking about his son?
Yes, he was.
And he kept saying, he's gone, I can't believe he's gone, I'm a good father.
I believe he said that.
And the defendant started crying when you told him that you were going to drive him to the station house, correct?
I'm not sure if I told him that or if Detective Booth told him that, but he did start crying after being informed of that statement.
Okay, so he was crying when he learned he was going to the precinct.
Yes, I would agree with that.
And while the defendant was in the back seat of your car, he stated, "I messed up," correct?
Yeah, he was saying a lot of stuff in the backseat of the car.
And the defendant started crying as soon as you sat him down in the interview room?
Yes. Yeah, and he had his head in his hands too.
And he told you that he knew what he had done to his son, correct?
Yeah, I can't recall when he said that, but he might have said that.
But he said it at some point. You'd agree?
I believe so.
The defendant said that he didn't mean to do it.
Yes.
And again, he kept saying that he was a good father, correct?
I think so.
Nothing further, Your Honor.
Okay, Ms. Ledesma, do you have any redirect for this witness?
No redirect, Your Honor. We are ready to call our next witness.
Okay, then the witness may step down and be excused.
Your Honor, at this time, I will switch with my co-counsel.
Okay, and we'll give the defense a minute to do that, but they may call their next witness. All right, Mr. Galvan, I think you're still muted. There you
Right,
go.
Your Honor. Defense
You may
now
proceed
calls-
when ready.
Yes, Your Honor. Defense now calls Dr. Riley to stand.
Dr. Riley, good evening. You are instructed that you are constructively sworn and have an obligation to tell the truth. You may proceed.
Could you please introduce yourself to the members of the jury?
Hello, my name is Dr. Shane Riley.
What do you do for a living, Dr. Riley?
So I am a licensed psychiatrist and I am the owner of Riley Forensic Psychiatry.
Were you certified by any boards to practice?
Yes, so similar to the other witness here, I was certified by the American Board of Psychiatry and Neurology.
And how long have you been practicing as a psychiatrist?
It's been almost 20 years now.
Have you ever served as an expert witness before?
I have 25 times, 18 being criminal trials.
And whenever you served as an expert witness, was that only for the defense or have you been with the prosecution as well?
I've been a representative of both sides.
What is forensic psychiatry?
So forensic psychiatry is a subset of psychiatry that looks at the intersection of our legal system and psychiatric conditions.
What did you do in preparation for today's case?
So I compiled an expert report that consisted of my own memory of treating Timothy Ray, as well as a review of the medical records and interviews that I conducted.
Did you use any reliable methods and principles?
Right. So I compared the testimony from multiple people and the entirety of the report and the interviews that I obtained in comparison to the DSM, which is a known and reliable method for diagnosing mental illness.
You mentioned the DSM. What is that?
As the other witness stated, this is the Diagnostic and Statistical Manual. It is something that every psychiatrist would use to diagnose a mental disorder.
Do you think that your testimony will help the jury understand today's case?
Yes, I believe it will.
Your Honor, at this time, defense tenders Dr. Riley as an expert in forensic psychiatry.
Okay, Mr. Ward, is there any reason why the court shouldn't accept this witness as an expert in that field?
No, Your Honor.
All right, she is so accepted. You may proceed, Mr. Galvan.
Thank you, Your Honor. Dr. Riley, how do you know Timothy Ray?
Right. So in 2010, I was a psychiatrist with the Army, and I actually saw him as my own patient back at that time because he was complaining of depression and sleep disturbances, and there were reports from his senior officer that he was seeing things.
Well, tell the jury what happened as a result of that interaction in 2010.
Right. So during the interview that I conducted with him, he had reports of feeling depressed and anxious. And I, at the time, diagnosed him with generalized anxiety disorder, gave him a prescription, and also recommended that he seek follow-up treatment with a therapist.
Dr. Riley, what happens if illnesses go undiagnosed and untreated.
Right. So that is a tragedy with the system, is that if someone goes undiagnosed or untreated for any reason whatsoever, especially with something like schizophrenia, the symptoms tend to gradually accrue and can worsen as time goes on without treatment.
Was 2010 the only time you interacted with Timothy Ray?
I saw him again in 2019, but in the interim of those 9 years, that was the only time I saw him.
Well, let's talk about the 2019 interview. How did that interview go?
Right. So I used a clinical interview in 2019 to ascertain the years that I had to make up between my 2010 interview and that interview in 2019. So I talked about the day of the incident, and I also talked about his childhood.
Well, what did y'all talk about with his childhood?
So with his childhood, he did confide in me that he had been seeing things that other people couldn't see. And he told me that he did not care to report that to anyone at the time because of his mother's mental illness.
What about things that were going on between his childhood and the day of the incident?
Right. So he had talked about hearing voices before. He described these as male voices. And he stated that as the incident approached, these voices increased, and they were what we as psychiatrists would classify as a command hallucination. So this is when the auditory voice that they hear is giving the patient commands, so telling them to do things. It is something very concerning for a psychiatrist and typically indicative of a mental illness.
What did y'all talk about regarding the day of the incident?
Right. So on the day of the incident, he reported to me that he was there with his son and that his son had spilled juice on his computer, and the voices had been present in building at that time. And at that time, they told him that this was an act of sabotage.
Well, the voices told him it was an act of sabotage. Then what?
So he forced his son to exercise as punishment, but and he described it himself as a creepy voice, kept telling him to strangle and kill Nathan. So he did.
Dr. Riley, how did Timothy act in the duration of the 2019 interview?
Right. So during the interview, he did act a little odd. He was sweating profusely and showing signs of paranoia. He did become upset during the interview, accused me of being a government agent, mentioned that there was a camera in my microwave. And then when I questioned him for some context on the day of the incident, he did give me a rather odd statement.
Well, we'll talk about that odd statement in a little bit. I want to go back to the accusations. Was this the only time that Timothy had made an accusation in your review of the report?
No, it was not.
When else did Timothy make accusations in your review of the report?
In my review of the report, it was not only to me, but he also accused Detective Booth and Officer Wentz of being in the CIA, which all took place after the incident occurred.
Did any accusations take place before the incident occurred?
Right. So prior to the incident occurred, he did have an appointment with his PCP. At the time, he did accuse her of listening in on his phone calls, which could be consistent with a delusion. And considering the fact that his later commentary about other people being in the CIA is also of similar context of people listening in on him, this would be a consistent delusion.
Let's go back a little bit. What was that odd statement that you had mentioned?
Right. So in order to ascertain kind of the severity of his presentation and the intensity of his delusions and hallucinations, I did ask him whether or not he would have still committed this act if there was a police officer present, to which he did say yes.
Dr. Riley, I understood that you conducted other interviews. Why did you conduct other interviews in your report?
Right. So this was to do my due diligence as a psychiatrist. Considering the fact the last time that I saw him was in 2010, and he only had he had some appointments with his PCP on the interim, there was plenty of time there for symptom presentation that might not have been seen by a medical professional. So I conducted these interviews in order to get context of his childhood, the interim, and what he was like at work and at home.
Were those additional interviews important to your report?
Yes, they were necessary in order to have this holistic approach of his record and holistic approach of how he presented in order to make my medical diagnosis.
Dr. Riley, you were here earlier when my co-counsel made a demonstrative with Dr. LaGreca, right?
I was.
And were you able to understand what they talked about?
I was. I appreciate Dr. LaGreca's viewpoints, but I think in consideration of the entirety of the report, I can elaborate.
All right. Well, and do you think elaborating on what we've done so far on the screen, would that help the jury?
Yes, I do believe so.
All right, let's do that. Dr. Riley, earlier, just to refresh your memory, my co-counsel talked about the symptoms and features of schizophrenia, and then if they were present in the record, to which Dr. LaGreca had agreed with all of those. And then, but I want to ask you if they were present in the record, if you agree, and also where were they exhibited? Is that okay?
Yes.
All right, so let's do that. Dr. Riley, where was childhood trauma present? How does that factor into schizophrenia?
So this was something that was present in the record. And as stated previously, childhood trauma is a contributing factor to many mental disorders, one of which is schizophrenia. Schizophrenia is a multifactorial disorder, but the fact that he does have this does point towards it.
And where was it exhibited in the record again?
So this would have been with my interview with his father, who commented to me about how his mother was neglectful and also suffered from her own mental illness. And so this would indicate more towards the childhood trauma aspect.
How does anxiety factor into schizophrenia?
Right, so anxiety is an unfortunate associated symptom of schizophrenia. It is something that is present in many people who have schizophrenia.
And was that present in Timothy Ray's record?
Yes, it was. It was a common theme throughout his record, and it was something that I myself diagnosed back in 2010.
Which I take that's where it was exhibited, right?
Yeah, sorry.
It's okay. How does hostility factor into schizophrenia?
So this is another associated symptom of schizophrenia. Schizophrenics can have a tendency to become hostile, aggressive, or show similar behaviors.
And were any of those behaviors present in the record?
They were.
Where?
So this would have been through my interview with his boss, who pointed out an altercation that he had with a fellow employee where he became very physically aggressive.
Well, let's talk about impairment for a little bit. How does impairment factor into schizophrenia?
Right, so impairment is something that you look for with any mental illness, and particularly with schizophrenia, as the symptoms that present would need to start affecting their day-to-day living and day-to-day functioning, which includes self-care and interpersonal relations.
Was that present in the record?
It was.
Where?
So this would have been in commentary from many people that he was generally an unkempt man, and specifically from his wife, who mentioned that he could go weeks at a time without bathing, and it could also point towards some of their intermarital issues.
Your Honor, I have to object at this time. Permission to approach.
Okay.
Your Honor, while the expert is entitled to opine on inadmissible materials, the detail to which this expert is going into the statements made to her veers into the territory of being a conduit for inadmissible hearsay evidence.
Okay, Mr. Galvan, do you have a response to that?
I do, Your Honor, but wait, may we move outside the presence of the jury?
Well, we have. We're constructively approached.
Yes, Your Honor. Well, first, I would like to point out that if this is this referencing the interview with Jessica Ray, or is opposing counsel commenting on Dr. Riley's testimony as a whole?
Well, I made the objection to what Jessica Ray told Dr. Riley, describing the contents of exactly what Jessica Ray told Dr. Riley during that interview.
Yes, Your Honor. Well, Your Honor, I'd like to respond to that because, well, first, on Dr. LaGreca's cross, Dr. LaGreca, and I actually wrote it down, explained actual statements from that interview with Jessica Ray, which is already opening the door to us being able to talk about this interview. Additionally, Your Honor, Dr. Riley has already explained that These interviews were important for her because she needed to take a holistic approach. And specifically with Jessica Ray, she explained that it was important to know how he operated at home and then how his behavior was. Additionally, Your Honor, under 703, Your Honor, inadmissible hearsay is allowed as long as it is substantially more probative than prejudicial. Your Honor, how Timothy acted at home and the inner workings of their marriage is extremely important in the jury understanding Timothy Ray and being able for us to prove our case of schizophrenia, Your Honor.
Okay, Mr. Ward, I'll let you get the final word on that.
Your Honor, the state merely objects to any sort of direct quoting of what the expert was told in their report. As to the use of inadmissible hearsay to form the basis of their opinions, the state rested their argument previously.
If I may respond, Your Honor.
Very briefly.
Yes, Your Honor. Your Honor, again, on cross, Dr. LaGreca used specific statements from the interview of Jessica Ray. Opposing counsel cannot use this as a sword and shield approach, Your Honor. They must be able to allow it to come in. And Your Honor, again, Dr. Riley has already explained how important this interview was to her overall report because it was a holistic approach.
Okay. I appreciate that argument from both of you gentlemen. I'll say this, solely on the issue of the Jessica Ray interview, because that's what's currently before me, and I don't think the objection was timely as to the other interviews discussed. I think that it has a very low prejudicial effect and some substantive value, probative value. So I will overrule the objection as a conduit to hearsay as to the Jessica Ray interview, but it is without prejudice, Mr. Ward. If you believe that this witness is continuing to be used as a conduit for hearsay, you may re-urge it. Okay?
Yes, Your Honor.
Overruled. You may proceed.
Yes, Your Honor. Dr. Riley, okay, well, Dr. Riley, again, you saw this impairment where again?
So this would have been through testimony from multiple people at different parts of his life, from PCP that was calling him unkempt, from his wife, and from testimony that we heard earlier today.
Okay. I want to move on and talk about delusions and hallucinations. How does that factor into schizophrenia?
Right. So this would be considered a positive symptom in schizophrenia, something required for the diagnosis. And delusions and hallucinations are a known associated feature of schizophrenia.
And were delusions and hallucinations present in Timothy Ray's record?
They were.
Where?
So this would have been present in interactions both with me personally and with the police. It also was seen in an interview with his PCP back in 2017, I believe. And also in the fact that he himself reported experiencing auditory and visual hallucinations leading up to the incident.
Dr. Riley, at the end of the 2019 interaction, did you have to make an expert diagnosis?
I did.
And what was that?
So as we can see here, these are not isolated incidents of associated features. These are looked at in their entirety. And if you look at the entirety of his record and the presentation of his symptoms, this is an unfortunate case of severe schizophrenia that precedes the date of the incident.
And going back to your report, did you have to make overall expert opinions?
I did.
And what were those?
So I had two opinions, one of which was, as I pointed out, that Timothy Ray, unfortunately, is has severe schizophrenia, and the other is that this severe schizophrenia would have caused him to become temporarily insane the day of the incident.
No further questions at this time, Your Honor.
Okay, Mr. Ward, do you have a cross-examination for this witness?
Do, Your Honor.
You may proceed.
Good evening, Major Riley.
Good evening. Before we get into this, can I please ask to be called Dr. Riley? I did go to medical school and I am here for my medical opinion.
Sure. Major Riley, Dr. Riley, you'd agree with me that it's harder to say that someone has schizophrenia in the absence of an actual diagnosis from a treating physician.
If I am a treating physician. Are you saying that if he hasn't been seen before?
No, Major Riley, the question I asked was, you'd agree with me that it's harder to say that someone has schizophrenia in the absence of an actual diagnosis from their treating physician?
Unless this is the first time they're being diagnosed with schizophrenia, then yes, I guess it would be hard to say someone has it.
So that's a yes.
Sure.
Now, Major Riley, Dr. Riley, you're aware that the defendant on trial today was treated by Dr. D. Giuseppe.
He was.
You're aware that the defendant has also been evaluated by Dr. Narasimha.
Who prescribed him Seroquel, yes.
And in 2010, you yourself evaluated the defendant's mental health.
I did.
Now, you didn't diagnose the defendant with schizophrenia in 2010.
At the time with his presentation, I had concluded that it was generalized anxiety disorder. Yes.
So that's a no.
Yeah, so no, I did not diagnose him with schizophrenia in 2010.
Dr. Di Giuseppe didn't diagnose the defendant with schizophrenia in 2017.
At the time, no, but I do believe she asked him to see a psychiatrist.
So that's a no.
No, she would have been a PCP.
Dr. Narasimhan didn't diagnose the defendant with schizophrenia in 2017.
She didn't, but she did prescribe him with Seroquel, which is a known antipsychotic.
So that's also a no.
No.
Now, to be clear, Dr. Riley, the defendant has never been clinically diagnosed with schizophrenia before now.
Before my 2019 interview, no, he unfortunately was not diagnosed with schizophrenia.
Major Dr. Riley, in fact, out of all the doctors that have seen, treated, and evaluated the defendant, the first one to conclude that the defendant has schizophrenia is you.
Considering there had been 9 years between my first instance with him and the instance that I did have, and in those 9 years, he only saw a couple doctors a couple times. Unfortunately, I was the only one to diagnose him with schizophrenia.
Dr. Riley, the question you answered was a little different than the one I asked you. The question I asked you was, out of all the doctors that have seen, treated, and evaluated the defendant, the first one to clinically diagnose the defendant with schizophrenia is you.
Yes, as I said, I was the first one to diagnose him.
Major, doctor, you're being paid in this case.
Similar.
Objection, Your Honor.
Yes.
Your Honor, this is outside the scope of direct.
Mr. Ward, Mr. Ward, would you like to respond to that?
Yes, Your Honor. It goes directly to the credibility of the witness, and the witness is biased.
Okay. I understand, Mr. Galvan, your point, but under the local rules, we're slightly constrained in terms of who can call whom and the order of proceedings. And I believe the Federal Rule of Evidence 611 gives me a little bit of leeway with those matters. So I note your objection. It's overruled. Thank you.
Yes, Your Honor.
Dr. Riley, you're being paid in this case.
Similar to the other expert witness, yes, I am being paid for my time and expertise.
Right. You're being paid by the defense.
Yes.
But you gave this defendant a discount, didn't you?
So I did serve in the military, and he is also a military member. So I did give a discount for that consideration.
Major, let's talk about why. Now, a couple of years ago, you recently started your own business. Is that true?
Yes.
The nature of your business is that you provide services to veterans who are parties in legal matters, right?
Yes, that is true.
Just like this defendant.
Yes, I was consulted for this.
Now, you said your business is also growing. Isn't that right?
Objection, Your Honor.
Yes.
Your Honor, the objection is for relevance, Your Honor. Now we're talking about the actual business of Dr. Riley, and the jury doesn't need to hear this.
Okay. Mr. Ward, would you like to respond?
Your Honor, this goes directly to Major Riley's bias, and it's important that the jury hears, and so they're able to properly evaluate how much weight to give Major Riley's testimony.
If I may respond, Your Honor.
Briefly.
Your Honor, Dr. Riley has already been admitted as an expert to this court. these questions should probably have already come up before, but they did not. Dr. Riley's already been admitted as an expert, and we don't need to know anything further about the business workings.
Your Honor, if I may.
I don't think there's really a need, Mr. Ward. I understand that she has been accepted as qualified and as an expert in her field by the court, but I don't think that's mutually exclusive to whether or not she has a bias in the case. And so I'll respectfully overrule your objection, Mr. Calvon. Mr. Ward, you may proceed.
Dr. Riley, your business is growing, right?
I believe so.
You want your business to continue to grow, correct?
As appropriate, yes.
Major, the more I'd like to talk to you about malingering. And just so the jury understands that when we talk about malingering, we mean faking or pretending symptoms of insanity for a defense, correct?
I am aware of what malingering is, yes.
We agree that the more serious the crime, the higher the likelihood of malingering.
Yes.
It's your opinion that murder is the most serious crime one can commit.
I think that would be a common opinion, yes.
During your interview with the defendant, when you confronted him with an inconsistency in his story, he had what you described as an angry outburst. Isn't that true?
Yes, as I noted in my report, this was something that was inconsistent at that time, but could also contribute towards someone who was severely schizophrenic having difficulty with their memory.
Right, and when the severity of someone's symptoms increase in the face of imminent culpability, the likelihood of malingering also increases. Isn't that true?
Severity of symptoms increasing, yes, that is true, but they would also increase if someone went untreated for a medical disorder.
So that's a yes to the question of whether or not the severity of some symptoms increasing in the face of imminent criminal culpability, the likelihood of malingering also increases.
Yes.
Major Riley, you would admit there's a chance that this defendant is malingering.
As I commented in my report, there was a chance. I did consider it. I did evaluate for this, and I diagnosed him with schizophrenia.
Right, but in your report you wrote, I cannot say with certainty that Timothy Ray was not malingering. Isn't it true?
Yes.
Nothing further, Your Honor.
Okay, Mr. Galvan, do you have a redirect for this witness?
I do, Your Honor. However, I would like a moment to confer with my co-counsel.
Okay, take a brief moment.
No redirect, Your Honor. We ask that Dr. Riley be excused.
Okay, thank you for your time, Dr. Riley. You may step down and be excused from the courtroom. Okay, does the defense have any more witnesses to call?
No, Your Honor. Defense rests its case.
Am I taken to understand then at this time that both sides do finally rest and close?
Yes, Your Honor.
Yes, Your Honor.
Okay, unless there's any objection, I think the award ceremony has been pushed back some. I'd suggest we take one more 5-minute break, make it a tight 5, so that the parties can prepare for closing argument. Does that sound good?
Yes, Your Honor. May we have a time check right now?
Sure. Why don't the timekeepers do that over the break, and they can tell us what time each side has remaining before we start closing arguments. By my watch, it is about 6:43 Eastern time. So please be back here at 6:48 Eastern time. Let's make it a tight 5. Thank you.
Yes, Your Honor.
Okay. Looks like we have a time check from the defense timekeeper stating that the state has 13 minutes, 45 seconds, and the defense has 8 minutes. Prosecution, do you agree with that?
Yes, Your Honor.
Okay. Any other matters we need to take up before we proceed to closing argument?
Defense is ready to proceed with closing arguments, Your Honor.
Okay. State, are you likewise ready to proceed?
Yes, Your Honor.
All right, then Ms. Pasculo, you may proceed when you are ready.
Child deserves to feel safe in his father's arms. Child deserves to grow up. Well, you have heard a lot today about the defendant. Remember the little boy who the defendant left in a shallow grave? A boy with green eyes and blonde hair who liked to eat Frosted Flakes, play with Legos. That same little boy who the defendant strangled to death and buried in a shallow grave in the woods of Brandywine State Park. The defendant killed Nathan in a fit of rage. But rage does not equal insanity. As the prosecution, we had the burden today in proving this case to you beyond a reasonable doubt. And we have proven each and every element of the crime to that burden, that standard. We had to prove to you today that Timothy Ray killed Nathan Ray with malice aforethought. That means intentionally and with premeditation. In order to find that someone kills with premeditation, you have to find that they decided to kill after a period of reflection, no matter how brief. Premeditation means that the defendant thought about it first, even if for a matter of seconds, then decided to do it anyway. Let's first talk about how the defendant killed Nathan Ray. And remember, we know about this. Every gruesome detail we know because the defendant himself confessed to Detective Booth. We learned that on the morning that the defendant killed Nathan, Nathan spilled a cup of juice on the defendant's laptop. The defendant was enraged, went back to his bedroom and got a belt, and with belt in hand, returned to Nathan's room and started hitting him with it over and over again. Nathan screamed and cried out in fear and in pain. He cried for his mother. The defendant wanted to stop that screaming, stop that crying for good. But he almost didn't do it. Sat on his bed, thought about just letting it go. That is the moment of premeditation. The defendant thought about it first and decided that he was going to go through with his actions. Wrapped that belt around Nathan's little neck and pulled it tighter and tighter till Nathan stopped breathing, stopped moving, and stopped screaming. Because of the overwhelming evidence that the defendant murdered Nathan, the defense has tried to convince you that the defendant should not be held accountable for his actions because of an alleged bout of schizophrenia. In order to prevail, the defense has to prove that the defendant was suffering from a severe mental disease or defect at the time of the murder, and that because of that, the defendant did not know or did not understand the physical nature and consequences of what he was doing. The defense has failed to meet that burden today for 3 reasons. 1, the defendant never exhibited any signs of schizophrenia. 2, the defendant knew what he did was wrong, and he tried to cover it up. 3, any symptoms that the defendant allegedly did show in that interview with Major Riley are a result of him faking it, malingering. Let's first talk about the defendant's lack of symptoms. You have learned about the defendant's background, about his upbringing, his work history, and his marriage. You have also learned that, like all of us, except for a few bad days, this history is pretty uneventful. Dr. LaGreca explained that nothing in the defendant's history is consistent with a diagnosis of schizophrenia. You learned that schizophrenics do poorly in school, but the defendant had a bachelor's degree in computer sciences and graduated summa cum laude from Skelton University. You also learned that schizophrenics have issues at work and difficulty maintaining jobs. But you learned that the defendant never had an issue at work, never formally disciplined, and he was even called a fantastic employee by his boss. As for his medical history, the defendant never showed any symptoms of schizophrenia, nor was diagnosed with it. And even the defendant's expert, Major Riley, had to admit that the single most important factor in diagnosis of schizophrenia is whether one has been previously diagnosed with it. In 32 years, the first and only medical professional to ever diagnose the defendant with anything more serious than general anxiety disorder is the one that the defendant paid to testify at his murder trial. 32 years, not a single schizophrenic episode, not a single schizophrenic symptom. And that is because the defendant is not schizophrenic. Second reason why the defense has failed to meet his burden is because he tried to cover it up. Tried to cover up what he had done. Meaning, he understood his actions and knew that they were wrong. Will bleach destroy a body? How to get rid of a body? Countries that don't extradite for murder. These are not the search terms of someone who does not understand the gravity of their actions. They are plans A, plan B, and plan C. Plan A, destroy Nathan's body with bleach. Plan B, get rid of Nathan's body by burying it in the woods of Brandywine State Park. Plan C, flee the country. When plans A, B, and C all failed, the defendant got caught. The defendant turned to plan D, desperation, as a last-ditch effort to try to get away with murder. And that is the third reason why the defense has failed to meet its burden. Because you learned that the defendant is just faking. Both experts spoke at great length about malingering or faking symptoms, and both experts agreed that in a murder trial, the most serious crime, that the odds of malingering are much higher. And that makes sense. The more that's at stake, the more likely that someone's going to try to get away with it. The defendant knew exactly what was at stake. He said so to Major Riley that he was afraid of going to jail for what he had done. The defendant had every reason to fake insanity, and he did just that. Try and meet their burden. The defense brought to you Major Riley, the first and only medical professional to ever diagnose the defendant with anything more serious than general anxiety disorder. Major Riley actually interviewed the defendant way back in 2010. And in 2010, Major Riley didn't think the defendant was schizophrenic, just like Dr. LaGreca, Dr. DiGiuseppe, Dr. Narasimhan. Major Riley didn't think that he had any symptoms of schizophrenia. So, what changed? Well, what changed is 9 years later, the defendant wrote Major Riley a check for a diagnosis that he hoped would get him off. Major Riley didn't take this serious. You saw today when Major Riley was on the stand, she laughed when opposing counsel mentioned childhood trauma. Major Riley is here for the money, not for an honest diagnosis. Then the defense also brought to you Officer Wentz, a witness who admitted on the stand that he has no medical knowledge or expertise and who never met the defendant prior to that traffic checkpoint. Rather than calling anyone in the defendant's life who had observed a symptom of schizophrenia, they called a cop who observed the defendant once and only after he had already killed Nathan and had every reason to malinger. They didn't call someone who lived with the defendant, who worked with the defendant, who knew the defendant well. The reason why they didn't call any of those people is because the defendant never exhibited any symptoms or signs of schizophrenia. The defendant is not a schizophrenic. He's just an enraged man who let his emotions get to him and did the unthinkable. Remember who the defendant took from this world. Smiling 6-year-old boy with his whole life ahead of him. A boy with green eyes and blonde hair, liked to play with Legos and eat Frosted Flakes. A boy who will never get to see his 7th birthday. Don't let the defendant get away with taking Nathan's life. Find the defendant guilty of murder in the 1st degree. Thank you.
Okay. Thank you, Ms. Pascula. Ms. Ledesma, are you ready to proceed with the defense closing argument?
Yes, Your Honor, just setting up briefly.
All right.
Also, Your Honor, before we start, will it be okay if my timekeeper or my tech advocate goes ahead and pops in on the screen so I may know when I have 1 minute left?
Yeah, that's fine.
Yes, Your Honor. May it please the court, opposing counsel, members of the jury. Undiagnosed and untreated is what led to the unexpected tragedy in today's case. It's how schizophrenia was able to steal 2 lives from one family on October 17, 2018. Now, there's one question my co-counsel and I have been asking ourselves since before this trial ever began, and that is how? How can a parent take the life of their own child? It's crazy. It's irrational. It's absolutely insane. There are no words to describe the pain and the grief in our hearts, not only for, but with the Ray family and their loss. But it is within this pain and grief that we went searching for the truth. And in our search for the truth, we found Nathan's killer. We found the killer that is schizophrenia. Schizophrenia is the killer that has been pulling Tim in and out of reality with waves of anxiety, depression, delusions, hallucinations, paranoia, you name it. It's like the ocean that pulls a swimmer deeper and deeper into its depths until the swimmer can no longer scream out for help because the water is trading places with the air inside their lungs and they're falling far below the surface. And like the ocean, schizophrenia has the ability to sweep us under and rip us away from the surface before we even know we need help. We're here today because the state charged him with first-degree murder. They promised at the beginning of this trial to prove to you beyond a reasonable doubt that Tim intended to kill Nathan. They promised to provide you with proof that was so convincing that you would be willing to rely and act on it without hesitation. But with each witness they called to the stand, our hesitation only grew bigger and bigger and bigger. See, we heard from Detective Boot today, who is supposed to walk us through his investigation. But what we really learned from Detective Booth is that he can only remember bits and pieces of his policies and trainings. He's an officer who called a sick member of our community a piece of shit who is better off dead. Detective Booth wants us to believe that Tim does not have schizophrenia, but Detective Booth is the same person who admitted on the stand today that he would not be able to recognize signs of any mental illness, even if it was staring him right in the face. Now, the state presented some Google searches today, members of the jury, and when we hear the phrase Google searches, there's only two things I'd like for us to remember. One, the state could not provide one witness today to testify that Tim himself made those Google searches. And second, not one of those Google searches asked how to fake a mental illness, which is primarily what the state argued today. See, their expert was called in to describe her opinion as to why she believed Tim was malingering. And what she said was so important. I wrote it down. She said, because of the lack of symptoms in the past and the lack of documentation before the incident, he's faking a mental illness. But we were all in the courtroom today when their expert agreed with me that there were reports within the record showing that Tim experienced childhood trauma, anxiety, hostility, and aggression. He was having trouble sleeping. He was fine one moment and then crying the next. He was locking himself away for hours at a time, isolating himself more and more over the years. He had become a completely different person even before his wife left. The record reflected that Tim was seeing things that nobody else could see, hearing things that nobody else could hear, and accusing people of listening in on his phone calls, believing that he's a terrorist, and asking them if they're working with the CIA. Signs and symptoms all consistent with schizophrenia, within the age range in which schizophrenia develops. But their expert refused to diagnose Tim with schizophrenia because of the lack of evidence. Members of the jury, where wasn't someone in Tim's life reporting that Tim was not well? We explained at the beginning of today's trial that the state would not be able to meet their burden because Tim did not intentionally kill Nathan. But we wanted to make sure that you had the whole story and not bits and pieces of what happened back in 2018. We wanted to be able to explain and understand how schizophrenia developed within Tim's mind and ripped him away from the surface. In order to do that, we took up a burden of our own, a burden of clear and convincing evidence, which simply means highly probable that one, Tim was suffering from a severe mental disease at the time Nathan was killed, and two, because of the severe mental disease, Tim could not appreciate the wrongfulness of his actions. In other words, because of schizophrenia, Tim could not understand the consequences of what he was doing. And we proved that it was highly likely that Tim was suffering from schizophrenia at the time Nathan was killed by calling two witnesses of our own. See, we did call Officer Wentz to the stand today, and Officer Wentz is a witness who would normally be testifying on behalf of the state. However, when we break down Officer Wentz's testimony, we can see the range of emotions in which schizophrenia controls in Tim's mind. We also brought Dr. Riley to the stand today, and Dr. Riley testified and explained her medical diagnosis of Tim. She explained how his childhood trauma, his 2010 evaluation, and the 9 years leading up to his arrest showed signs and symptoms all consistent with schizophrenia. Dr. Riley explained that when schizophrenia said, strangle him, kill him, Tim's ability to act and react faltered, his memory faltered. Schizophrenia has the ability to drag us deeper into insanity as the fabric of our reality unravels. Members of the jury, the law understands that tragedy is not limited in the forms that it takes. We understand that because we came together as a society and we asked ourselves, when our mind turns in on itself, who do we turn to? Members of the jury, it's you. We turn to you and we ask for justice, that Tim not be blamed for what schizophrenia did. Schizophrenia already stole one life from this community, and we are asking you to salvage what it is taking from another. Because Tim lost his son too. And nobody benefits when somebody is sick. We ask that you find him either not guilty or not guilty by reason of insanity, because those are the only verdicts today where the law and justice meet. Thank you.
Okay, Ms. Pasculo, do you have any rebuttal?
Yes, Your Honor. One moment to adjust my camera.
Sure.
The defense just argued that we don't know whether Timothy Ray made those Google searches on his phone. They arguing that someone knew the defendant killed his son, and that same person knew that the defendant was going to raise a defense of insanity, and that same person then put those searches into his phone in order to frame him? That's not clear and convincing evidence. Then that same person who hacked into his phone went to the store, bought 2 big jugs of bleach, a shovel, and garbage bags, and then got into the defendant's car, put it in the back seat, and then went into the defendant's home, got Nathan Ray, and put his lifeless body in a garbage bag in the woods of Brandywine State Park? The defense is right. They didn't search for a mental illness. He searched for something much worse. He sat there in his house, typing precise and well thought out.
Objection, Your Honor. Misstatement of the facts.
Overruled.
Yes, Your Honor.
The defendant sat in his house, typing precise and well thought out search terms into his phone, with his 6-year-old's lifeless body sitting in the next room. How to get rid of a body. Will bleach destroy a body? Countries that don't extradite for murder charges. Murder. Extradition. These are not the words of someone who did not understand the consequences of their actions. These are the words and thoughts of a person who was lucid and calculating. If he was truly not conscious of his actions, or if he was truly not aware of what he had done, once this alleged bout of insanity was over, he would have called the police, a doctor, his ex-wife, anybody, and tell them something happened to Nathan. Instead, with his son's dead body still lying in his home, he is desperately trying to figure out a way to escape accountability for what he had done. Then gets a shovel, garbage bags, tries to dispose of Nathan's body. Remember those search terms. Remember how Detective Booth described how Nathan's body was found in a shallow grave in a garbage bag in the woods of Brandywine State Park. Remember Nathan, smiling 6-year-old boy, blonde hair, green eyes. Never will get to see his 7th birthday that he so deserves to see. Don't let the defendant get away with it. Find the defendant guilty of murder in the 1st degree. Thank you.
Okay, thank you both. With that, I will submit the case based on the evidence to the sound judgment of our jurors. Jurors, please fill out your ballots and submit them as you're instructed. And once that occurs, let me know in the chat, and we will do very, 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 very brief comments while we're waiting for the all clear. Please, everyone, stay on the call until we do get the all clear, just so we have everyone in case we need you. Okay? Okay, everyone, I've received word from our tournament director that we should be good. The advocates, I think there's another courtroom going that has maybe 10 minutes left. So we have time for very, very brief comments. I'd ask the jurors to pick one thing for each side, either to improve upon if they advance, or a favorite moment from trial, something like that. And with that, I'll turn it over to Juror May first.
Greetings. My name is Melissa May. I am a judge on the Indiana Court of Appeals, and I also teach trial practice at McKinney in Indianapolis. So first, I want to congratulate you on an excellent job. I thought both sides did a really, really good job. I just have a comment which really goes to both sides. All of you were very strong in your knowledge of the facts, obviously, of the case. One of the things you have to be extraordinarily careful about with experts, though, is if you give them an inch, they will take a mile. And the longer that your cross-examination questions are and the more complicated, the worse the answer can get. So just with everybody, as you deal with experts, because that was one of my favorite things when I was in practice, is to deal with experts, keep it as short as possible, because otherwise they'll gut you and kill you. So anyway, congratulations to all. I gotta go. Thank you. Sorry, big dog.
Thank you. Juror Nielsen, do you want to go next?
Hi, everyone. My name is Maggie Nielsen. I'm a Drexel trial team alum from 2012. I'm a Colorado attorney, and right now I'm living in British Columbia. So I've had quite the career already. But I think I totally agree with Juror May. You guys did a fabulous job. Everyone was really prepared, really knew their stuff. I thought everyone's direct exams were very conversational, which is hard to do. And I also agree about just tightening up cross with the experts, especially. And the defense, I think you objected a few too many times that you probably knew that wasn't going to go for you. So just maybe rethink some of those, but fabulous job, everyone.
Okay, Juror Berger.
Yeah, great job. Just echoing everything that was said. My name is Scott Berger. I'm an attorney here in Philadelphia. Practice primarily personal injury, catastrophic injury cases. You win and lose cases on cross-examination and on closing. And you got to tighten those areas up. And you always, if you see another side give you an opportunity with a little bit of a hypocritical argument, you got to take that up in your closings. I think both of you had opportunities to do that today, and you may not have hit on those. But it's dynamic. Excellent job, both sides.
And I concur. Y'all did a great job, and I especially appreciated the passion that both sides showed. That's something that can't be really taught. You just got to feel it, and I can tell all four of you feel it. So good job. Congrats. Be proud of yourself, and good luck to you in the rest of the tournament. Okay? All right. I'll see you guys. I'll end the meeting now.